Roll call. Mr. John Borden,
Present.
Mr. Furell,
Present.
Mr. Reposa,
Present.
Ms. Horowitz,
Present.
and the chairman, Mr. Nod, is here as well. These are the only members of the board. Next item on the agenda is the approval of the minutes of October 21st.
Mr. Chairman, I would make a motion. We approve the minutes of October 21st.
May I have a
As
second?
Mr. Chairman, I second it.
Motion's been made and second to approve the minutes of October 21st as presented. All in favor?
Aye.
Opposed? Next item on the agenda is the chairman's report. The members of the board, and this does not happen very often, I can't recall the last time we had, but an appeal has been filed on a decision made by the planning board by Namali Power LLC. And the zoning board sits as the planning board of appeals. So we have to hear this. Now, it's been requested that we hear this sometime between the week of March 7th through 11th. So I don't know if anybody has any preferences. I'm available any evening.
Mr. Chairman, I would ask, in that window, is there a Thursday?
Yeah, that would be the 10th.
So I would move that we have a special meeting on the 10th to address this appeal.
Okay,
Mr. Chairman, I second the motion.
all right. Motion's been made in second to hold a special meeting to convene as the Planning Board of Appeals on March 10th at 7 PM here at the Town Hall. All those in favor?
Aye.
Opposed? Okay. And just so everyone knows, and you will get all the information, it is not, basically what the appellant is saying is that the hearing was not done in a timely fashion. It was denied, and all this board will do is decide whether it was heard in a timely fashion in accordance with all the general laws of the state or not. So we will not be hearing the whole planning board petition. So we will convene on March 10th.
Mr. Chairman, you
Yes.
mentioned we will be getting backup
Yeah.
for,
Correct.
to
Mike, you'll be getting
make a-
everybody the information, correct? Yeah. Yeah. we will get
make
that.
an educated decision.
Oh, yeah. I can't remember the last time we had to do that. Can you?
No.
No, I cannot. Okay, moving on. There are going to be 3 continuances tonight. The first petition under old business of Christopher and Mary Carrette, they are not here tonight. They have been notified that we do need to continue it, unfortunately, because Mr. Furell has a conflict of interest. And we only have 5 members, down 1 is 4, so.
Mr. Chairman, I believe at our last meeting, our attorney mentioned or at least I understood that he said, if we were down to a bare quorum, then I would be able to sit.
However, we're not yet. Okay, Mr. Wadika, who will be resigning, has not officially sent a letter to the town. He's emailed us, but he is. So could I have a motion to continue the petition of Christopher and Mary Carrette to our regularly scheduled meeting of March 17th?
So moved.
Could I have a second?
Second that move.
Motion's been made and second to continue the petition of Christopher and Mary Carrette to our regularly scheduled meeting of March 17th. All in favor?
Aye.
Opposed? Next item that will be continued will be under new business, will be number 3. The petition of George and Marie Corey requested they need to go to the planning board before coming here. So they've requested to continue to our regularly scheduled meeting in March. So could I have a motion?
Make the motion to continue that.
Second.
Motion been made and second to continue the petition of George and Marie Corey to our regularly scheduled meeting of March 17th. All in favor?
Aye.
Opposed? Okay, and the last is Karen Blumstead here. Is she online, Mike?
Karen, if you are online, could you please raise your
Yeah,
hand?
she is there. I see her on there.
Oh. Yep.
Hello,
Hi, Karen, how are you?
I'm very well. How are you?
Good. Regretfully, we have to continue your petition because I received a notice that I'm in a butter to your property.
Okay.
So that creates a conflict of interest. However, there are some certain special circumstances, especially in my case. So I'll be talking to the solicitor about going to the Ethics Commission to be able to hear this next month. So we are going to have to continue this to next month.
Okay, so this will be next month, the third Thursday of March?
The third Thursday of March, that is correct.
Okay,
March 17th.
Right. Okay,
thank you. Yep, that's
Righty.
fine. Thank you, and we'll see you in March.
my apologies.
Okay, no worries.
All right, can I have a motion to continue the petition of Karen Blumstead to our regularly scheduled meeting on March 17th?
So moved, Mr. Chairman.
Could I have a second?
Second.
Motion's been made and second to continue the petition of Karen Blumstead to our regularly scheduled meeting of March 17th. All in favor?
Aye.
Opposed? Okay, that one moves. All right. Next item on the agenda is a petition of Aquidneck Country Club seeking to amend a previously approved special use permit to develop 22 single-family dwellings and 6 duplex units on tax assessors map 26 lots 2, 2A, 2B, 2C, 2D, 3, and 4. Mr. Chappelle.
Good evening, everybody. I'm just spreading out a couple of things. Because I have some backup.
All right, Mr. Chappelle, before you get too far along, we have an issue. I think you know what that issue is.
I think that's why I just grabbed a table full of papers.
We have a special use permit that expired in 2010. It's now 2022.
I understand that, but I will address that.
Okay.
And to do that, I have to take you back in time a little bit. But I'm going to begin. I spent the day or the week looking in the archives of what has been here. You're the only one on this board that appears, well, not on all of them. John, I think, was on and off there a bit. But if you go back to 1997, Kaiser Aluminum was the tower, is what we all remember. Only it wasn't just the tower. It was the tower and a 750,000 square foot warehouse, taking up about 10 acres of land. Usually you try not to act old, but I'm old. And because I'm old, I sit at my father's desk. We have what we've been doing since 1952 is every time there's some cool event in the world, whether it's JFK's assassination, election of Obama, we grab that newspaper and they're in the base of my desk. And he thought it important to have the Kaiser aluminum paper. Kaiser aluminum paper from April of 1998 shows there was much more than a tower. A 750,000 square foot building and about 100% lot. And I think that explains, when we go forward to 1997, that there was an elephant in the room. There was a zoning board that had an abandoned tower and an abandoned factory. And it was, what are we going to do with this? And what's it doing for our town as a vacant building? Should we keep it industrial? Or should we listen to some of the people that were standing before us? A gentleman by the name of Andrew Patakiewicz came in and he proposed to make it a special use permit. Please remember, it's heavy industry. If you look in Article 5, Section 1, a hotel is allowed as a special use permit. So is a golf course, so is a marina, so is a club. But what is not allowed are condominiums, apartments, and townhouses. Single-family homes are allowed by special use permit, but it's there. Mr. Patakiewicz got the approval for a 450-unit hotel. He never dug a piece of equipment into the ground. He never did anything but move to try to sell those permits. By then, a gentleman by the name of Peter DeSavery had entered Portsmouth, and he made an arrangement with the golf course, Portsmouth Abbey, and built the golf club. The first relevant decision is a decision dated October of 2001. And it says, this matter came to be heard before the Portsmouth Zoning Board of Review.
Mr. Chappelle, just before you move on, could you specifically state the lot and plat number? Because again,
I can.
that was one, this is a separate lot from that development.
I assure you, I will point out all the lots in
Okay.
all of the petitions. I think it's fair to say that the first one included lot 10 because it references the Kaiser Aluminum parking lot across the street. But before I'm done with the decisions, I guarantee you will see that the special use permit runs on all of the land and now even Carnegie Heights. But on this particular petition, Mr. Galvin, with the testimony of Mr. Savory, Blake Henderson, Paul Hogan, all guys that stood before us all the time back then. Savory explained that he owned the neighboring Carnegie Golf Course, and he had been interested in the subject property, which is again, the Kaiser Aluminum property and lot 10, the Kaiser Aluminum parking lot across the street. He purchased it without conditions. He testified he had attempted to find suitable industrial tenants, but he was unable to do so. Project would be associated with the neighboring golf course, and he would join it to the Carnegie Club. It would remain ownership of a considerable amount of the units and used by its members. The remainder would be marketed and sold to members who were being encouraged to lease it back to the club. He anticipated primarily seasonal occupancy. The project would also include a restaurant, a marina, and the restaurant open to the public. Not sure that ever happened. The marina would also offer slips to the general public. Fishing pier would be restricted to a marina and their guests. The board determined after a vote on a special use permit to alter the special use permit that was granted for a hotel to turn it into, this is the first reference of a resort. And it was 108 units, 24 motel rooms, the golf course, et cetera, et cetera. It was done. I'll actually read you the decision. The board considered the project as proposed with the conditions imposed by the board and determined that the project would not be detrimental to the surrounding area, would be compatible with neighboring land uses. Further described the project would not constitute a nuisance or a hazard. The proposed safe vehicular access, further solar rights, all the things we usually do, unanimously granted a special use permit to Article 7, Section D. If you have your ordinance, I have copies for you, but Article 7, Section C is apartments, townhouses, and condominiums. Article 7, Section D is motels and hotels. So it was developed under Article 7, Section D.
Now, when you say developed, you're talking Carnegie Abbey property where the tower was.
I'm going to keep going.
Okay,
Because-
and I just, forgive me for interrupting, but I want to make sure that we're all clear that this particular lot, which I know as the original boat storage marine repair lot, okay, which came up much later, but go ahead.
Mr. Chairman, if
Yeah.
I could, just to get calibrated here, the petition is to amend a previously approved special use permit. And to the chairman's point, it's expired.
Right.
So that's what I haven't heard any testimony from Mr. Chappelle yet, why they're there in front of us to amend something that's expired.
But I think what Mr. Spell's trying to do is show us that he believes that the special use permit encompassed everything. Am I correct?
Yes, and
Where-
just, if you just hear me out, if that's your vote when I'm done, that's okay. But the first thing is, Mr. Knott wanted to know if lot 10 was included in this original special use permit, okay?
Well.
So in this, let me finish. It says 108 resort units consisting of 22 detached residences. Those would be the houses around the tower.
We're talking
51,
around the tower, Mr. Spell. Can we get over to this particular lot, please?
51 townhouses, 39 separate buildings. The grant of this permit is specifically conditioned upon compliance with Exhibit A. Exhibit A specifically references prior to issuance of building permit, Lot 10 on map 26 be merged with Lot 11 on map 26. So it was part of this petition. And if you remember back then, 10 used to be two
But was
lots.
it merged?
10,
It wasn't merged.
no, Jim. 11 doesn't exist. If you look at the tax map now, 11 was a piece of 10. 10 and 11 were merged. 12 is owned by Narragansett Electric. 10 and 11, they wanted the parking lot and marina service area merged.
They came here for a special use permit for that marine storage and repair building, separate from the Carnegie development.
Well,
So if that wasn't the case then, or now, why was it the case then? I mean,
all right.
why did they come for a special use permit for that?
They came for a special use permit for the hotel. They then had to amend the hotel for the resort units. Lot number 10 was included originally. I can show you every petition that you've sat on has included all of these. Let me start with the one that you say is expired. Don't just look at the decision. I have a copy of Mr. Gordon's application. The application, tax assessor's map, map 26, lots 2, 2A, 2B, 2C, 2D, 3, 4, and 10. 11 didn't exist, it had already been merged. The petition says, Article 5, Section 1, and Article 5, and it is entitled Amendment of a Special Use Permit. If you look at the attached sheet, petitioner and its affiliated companies have approval for a multifamily resort complex on the above referenced lots. Said approval initially included approval for a marine service complex on lot 10. Among other factors, regulatory review by Rhode Island CRMC drastically reduced the size of the proposed marina, which negated the need to dedicate lot 10 as a marina service facility. A marine service facility on lot 10 to service only 41 slip marina simply is not a viable project. Consequently, lot 10 was before you and subsequently approved as the location for overflow parking for the tower and marina. In July of 2006, the board further amended the special use permit, relocating all of that overflow parking to lot 4, parentheses 14, which I think is the upper lot where the sanitation facility is, which is closer to the marina and tower. So they then pitched under the original special use permit with all of the numbers to take lot 10 and to make 36 units out of it. And in 2009, this board granted that. Now, the argument that you have is even though you amended an original 2001 permit that was amended in 03, 06, 07, and by the way, in 2021, court was here twice in 2021, citing, and so was Adler Pollack on Mr. Tesla's. He came in, I get it, but if you look at the applications, they all say amendment to the special use permit, the following lots, because you approved them as a whole. We can't get rid of them. When you approve things as a whole, you consider density as a whole, you consider parking as a whole. You can't just treat this independently. It has to be treated as part of the original special use permit. I question, and tonight's not the night for it, even though you approved those in 2009, the phases of a condo do not necessarily have to be built within 1 year. Doesn't matter whether you write it on the same stationery we always write it on. In 2009, documents in the condo were changed. They were changed to say lot number 10 is no longer parking. Lot number 10 is no longer the marina service. Lot number 10 is now 36 units. And here's how we're going to assess them. There was an easement given across the road in Newport Beach Club because Mr. O'Neill owned both pieces. $75,000 fee was paid for that easement. And the DOT and railroad signed an agreement that we could put a culvert under the railroad. That culvert was installed knowing this was coming. In fairness, it was well after a year, but remember that whole tolling statute was interesting. So if you still look at your decision in 2009 as a single special use permit, it is expired. And we might just be here saying this is a new special use permit, but it was never done that way. It was, it was 6 lots and we have to. The condo docs all call this 1 unit. We can't change condo docs. We have to notify, what now, 200 people or different places in the condo that we are adjusting things. And that has to be done as a giant special use permit. Another question that was interesting is you really did it. Might be great foresight, might be, I don't think anyone's complaining about what is happening down at Carnegie Abbey or the Equipment Club, but you technically didn't really have the rights to do what you did except through that old ordinance that said, pick the next closest thing. And I understand that. Then they passed a resort ordinance, but the resort ordinance was not passed in 2010. It was passed in 2006. So the resort ordinance, the PUD that allows you to go for the very thing that you guys created without that ordinance, was not utilized on the day you got the 36 units. They said, we're not going to the planning board under the old one. We already have a special use permit. We can't, we have to go under the old grandfathered way. That's our only tool. And they did, and they got the approvals. It's just the time is, I don't think this would have been an issue if it was done 2 years later and a year went in. You would have said, oh, it's a special use permit. And by the way, you guys have spent this and done this and done this and done that. We know that maybe the economy says you're not going to start a building this week. And I don't even know that it's expired. But if we're just modifying it, I guess it doesn't matter if it's expired because we're seeking to modify. So I think all of the history of this and treating it together leave us no choice. We didn't file this randomly. Mike and I had a conversation. Do I go there or do I go here? Even if you went to the planning board, and by the way, you referred it to the planning board. And John, I think I got accused of picking in things, but I wasn't picking in things. I was trying to say what the town did to ratify what you did at Carnegie so they could recreate it at the Newport Beach Club. We will go to the planning board and show that if we went under the new one, we could do it. But we can't. We got to go over the old one because we have to have our documents. Every time Mr. Tesla, when he came in to combine that lot, and Miss Asness, when she came in to break up that lot, why do we need a special use permit to get rid of land? But we had to do that because that's what banks require. That's what lawyers require. That's what condominium documents require to change them. They can't be unilaterally changed by some guy that's the new president that says, let's just unring the bell. You get a public offering statement, you rely on what is in front of you. And this happens to be a bigger thing that's in front of you than getting rid of a lot. But all of this stuff has to be done procedural for us this way and procedural. Whether you like it or not at the end of the day, you don't have to amend it. If you don't amend it, there may be a legal battle someday about whether or not we have rights to not build what we don't want to build.
Mike, question for you. Lot 10, do you know where it stands in the tax records?
believe it's owned by the equipment. Club.
Is it separate from the other lots?
It has its own vision appraisal card that lists it. I believe it's
Separately?
6 acres.
But so does 2A, 2B. I mean, there's got to be 30 different cards down there. Now, if I can point out one more thing that's interesting. Remember Carnegie Heights? Carnegie Heights was across the street. Carnegie Heights wasn't developed originally under the special use permit. Carnegie Heights went to the planning board as a subdivision. And then let me find it. And then Mr. DeSavery came in front of the board, and the sole issue in front of the board, and this is in 2008, was I moved to make Carnegie Heights part of the resort so that it's part of the package, so that it can be put in our condo docs, and any future modification in Carnegie Heights would come as a special use permit modification instead of a subdivision regulation modification. And the board granted that.
So what you're saying, Mr. Chappelle, is a special use permit never expires.
I guarantee if let's go across the street to Albin.
No, let's just
Well,
talk about this property.
But here's the difference. Across the street at Albin, I came in here and had approved 23 lots. Nothing got started. No condo documents were filed. No easements were bought. No things were put in. No stopping because of economy. The whole thing just never started. If something never starts, that's one thing. Oakland Farms has 500 units. If I come to modify that special use permit and get permission to put in 3,
So if
That's
I
different.
understand your argument correctly, that means that Clements Market could come up here tomorrow and say, we want to modify our special use permit for our grocery store, and we want to do X, Y, and Z.
they have to.
Probably have to apply for a new special use permit.
No, they have to apply to modify their special use permit, because you can't have 2 special use permits running under the records recorded in land evidence that are not in common. If one of them says, don't come 50 feet away, and one of them says 30, that's not good. You want one document to say, and that's how we trace them. And that's how this one, when you looked at Tesla's application, which I have here, it says, this came before you in 1997, then in 2001, then in 2003, then in 2006, then in 2008. Now I'm here to do this. So that's the way it's always been done. This just seems more controversial because of all this piece isn't started.
Mr. Chairman, I would like to get the solicitor's opinion as to whether the special use permit has expired or whether Mr. Chappelle's argument is such that they can proceed.
Gavin, are you on?
I'm getting on. I mean, it's a very complex, can you hear me? I'm not sure if I'm, am I on there?
Yeah,
All
we
right.
can hear you.
I mean, I don't think it's really fair for just to punt it to me and say, can you do it or can you not? I mean, it's very complex. I think Mike has put a very, thorough staff report that raises a lot of issues, but I mean, on the face of it, it's expired. But I mean, I think let Mr. Chappelle make his arguments, and I think it's up to the board to decide.
So I guess I'm confused. What's your opinion? Do you think that it's expired or not expired?
Well, that particular decision expired, but I mean, court's making an argument that you gotta look back at go back to the 2001 and the overall, the first special use permit for the whole development. I mean, I'm not sure I'm following everything, but I mean, I
get
think
what you're saying, Kevin, you're saying that the previously granted modification has expired.
That is another way of looking at it. But either way, I would
But
still
now-
be
but
here
now
as
you
a.
can't compare to what was approved before.
Well, I can compare because you don't have to listen to the compare maybe. When I compare, I still can say to you, this was granted by someone else and found not to meet the A through J criteria. What you would be able to say is, if I dump this, I don't have to worry about the worst one that was there. Because if I don't like this, they have to come back with something I like. If I was correct that the first one didn't expire, if you don't grant this, I could try to build what I didn't want to build. But that's an issue that would only come up when I went to file a building permit for 36 units. And then I'd appeal that building permit, and then maybe we'd be back here, although I may already know the answer. But even if John or everybody's correct, if you say that modification has lapsed, I still am here on the modification of the original, and it would affect how you weigh what happened last time. But I'm still going to say, you know, another smart board said yes, so this is less, whether you buy that or not.
Well, I think there's a lot of things that are going to be put on the plate and hope that we would buy such that when it gets down to density, that you're going to take the entire development, everything, and say, hey, look, it's not dense. If you take it as a whole, across the street, everything, it's not dense.
Absolutely.
And if it looks like a duck and walks like a duck, it's pretty much probably a duck. You
Well,
know, that's
look,
kind of the issue here.
again, but in fairness to the Equipment Club, they've been pretty good neighbors, right? They come in here and get 36 units approved, and they sit here, and these exact same arguments were made by you. You can look at the application decision and say, the Carnegie Club said that if you included the land of the golf course in 2A and 2B and 4 and 5, there is 1 unit per 2 acres. Under the new resort ordinance was there's 2 units per 1 acre. And then you went on to say, even if you only look at the 80,000 square feet exclusive of the golf course, we still get to 17,900 square feet per unit. And I don't want to call it the close enough rule, but the board said it's consistent with R20, which is in the area, and we grant it. You didn't even grant any variances to that. You just granted a special use permit. You've said, when there's variances and a modification, you normally have a vote on variances and then a vote on the special use permit. No vote on variances. Vernon came and said, I don't believe we need variances because we're here as a special use permit modification. We all know that this lot standing alone as an Article 7 we can't do this. As an Article 7 standing alone, that doesn't do it. But what the town, not only did the town agree with you, they ratified you by passing a resort ordinance, which is virtually identical to what you did. They said, take the land that you're devoting to the resort. As to that land, please give me some commercial stuff, make sure there's amenities, give me some townhouses, some apartments, and some individual housing, right? All set in that ordinance. And give me some open space by doing that. Under the Carnegie Club, the tightest, densest units that match these are the Carnegie Villages. Everybody's pictured them, but you know they're all 10 feet apart. And under the Newport Beach Club, they're all called the tennis villages, where they're all kind of right on top of each other. But that was done to free up land in another spot. And it's kind of unfair to say that the golf course is open space because we probably know the Abbey wasn't developing, but now the Abbey won't develop, can't develop because it's all included. But not that that was a great risk to the town that the Portsmouth Abbey was going to go under.
Mr. Chappelle, let me stop you there. Seeking to modify a special use permit. And everything I read, see here refers to the modification that was granted in 2009.
That is because that is the modification that was
That is
last
expired.
before
So now what
on
you're-
this.
So now what you're seeking to modify is what was originally proposed there, the marina building. So all
Well,
your density and everything,
Everything's expired, Jim. That argument doesn't work. If you grant a resort ordinance and say that lot 10 can be a marina service building, and then you come back 2 years later and say it can be a parking lot, and then you come back 2 years later and say it can be 36 units, and then you come back, say 36, can I do this? It was never 36 units, check. It was never a marina service, check. It was never a parking lot, check. It has always remained undeveloped land of part of this that was dedicated 3 different times for 3 different uses and approved 3 different times. This is just the 4th time that someone's changing their mind, whether the special use permit, whether it was last week or 17 years ago. We have a right to come in and say, we have vacant land here that is not allocated in any of our density requirements, because if it was, you wouldn't have put 36 units on it, right? And we have a vacant piece, and when you look at it as a whole, we believe we can satisfy A through J criteria.
Yeah.
And maybe we can, maybe we can't, but you're trying to stop me before we even you hear the petition.
Mr. Chairman, just to your point, to summarize and bring this to a conclusion here. The original 2009 special use permit is valid for 1 year?
That was a modification to the original.
Okay, so-
According to,
All right, let me
but
finish.
that expired.
All right, so let me finish. So if that was valid for 1 year, my thought is, regardless of all of his arguments, it's expired and he needs to start over again.
And it's a modification to a special use permit still.
But-
However,
Well, go
a lot
ahead.
of the reference is to that 2009 decision, which is irrelevant. You know, to go in and say, well, 26 were approved and now we want to do this. And well, let's go back to what was originally
I mean,
granted.
this board has heard so many petitions where it's expired and they have to start over again. I don't understand this convoluted argument that it's still a modification. It's expired. Start over again.
If you, again, starting over is starting over. It's still a modification of the first one. Maybe not a modification of the 2009, but this land got included with all of those. Let me give you an example that I think would work. You come in here on a special use permit to put in 50 units. And I have a 20-acre field and a 10-acre field. And I say, I'm going to put 50 units on the 20-acre field, but I'm dedicating the 10 acres to open space. You think I can come in now, 2 years later, on an original special use permit and go, disregard the first one, fellas. I know this is included, but we're going to pretend that one doesn't exist. And I want to stand on alone and try to put 10 units on this. You're going to say, when you combine these lots into decisions, those decisions all run together. And just because we're not going from open land to obnoxious, but obnoxious to less obnoxious, doesn't make it any different.
All right, let me ask you this, Mr. Chappelle. Let me just state this, okay? A lot of the criteria and a lot of the data in here, you're showing drawings of what was approved in 2009 versus what you want to do, correct? 2009 doesn't exist, it expired. So, hang on.
But wouldn't I show that to you?
No, it expired. As far as I'm concerned, that's irrelevant.
First of all, I
Now
don't
it
take the
goes-
position.
Now it goes back to square one. The lot is empty, correct?
If
The
you,
lot, just answer the question, yes or no, the lot is empty.
the lot
Nothing on it.
is empty.
So why not, even if you're gonna modify a special use permit, come through with everything showing just what we want to do now. That's it, not referencing what was approved but expired in 2009, because that's totally irrelevant. It doesn't exist. It doesn't exist.
First of all, you have to rule that it doesn't exist, and that's okay. And I can at least preserve some appeal rights on whether it exists.
Well, it's.
Now, but either way, you think it really matters? Now, here's what matters. If I come back next month, like you say, with an amended petition saying just lot 10, I still have to include all the other ones. I still have to look at it as a whole. You
But-
just don't want me looking at the old one. But this is almost,
And that's correct, because what I don't want is smoke and mirrors. Well, look, you did this, so we're gonna put a couple of duplexes, a single, where this was, it, and then next thing you know, it's, you know, which one is the ball under which cup? And that's what ends up happening. Especially in fairness to the other
I don't
board
agree with
members who
that,
were
but-
not part of this way back when. It can be very confusing. And I think that's the only fair way to do it, period.
that would just be whether I shut my mouth on references to what was there. Because if you're saying it was irrelevant that you granted it then,
It's irrelevant in the fact that.
it's a different
that-
board. I get it.
That amendment or that special use permit change has expired. No one ever acted on it. No one ever did anything with it.
Well,
It's not there.
again, the condo
Am I
docs
correct?
reflect it. It's been recorded. There's been a lot more. You know, if this was a subdivision and we recorded the subdivision, we'd be done. There's no such thing as the fact that I didn't build a house on it expires. That wouldn't have happened. This is all recorded in condo documents that have been accepted by the town. So I'm not sure I agree with you. I'm trying to proceed.
I get that, but I don't
regardless of
think you're
that.
getting my point,
I
Mr.
get it.
Spell, my point is that there's nothing recorded in the condo documents that says all of these condos on that lot have been built. There's nothing there. It's empty.
Of course,
So you cannot refer to something.
until you get a
that's not
building
there,
permit,
that's
nothing
expired.
ever happens like that when you get a subdivision. Never, we don't record anything but the building. As soon as the building, the plan's recorded, the plan is recorded. We can go
So
back and,
We could debate this for another 2 hours.
Mr. Chairman, I would move that Mr. Chappelle summarizes his argument and then we vote, because I think we're going in circles here.
I totally agree.
again, I think you can look at it two ways. So I think you need to consider two different votes. First vote is whether I'm proper to be here under the amendment of a special use permit for lots 2, 2A, 2B, 2C, 2D, 3, 4, and 10, which is exactly how you handled all amendments in 2003, 2006, 2008, 2012, and twice in 2021. Because both of the petitions in 2021 for the Carnegie Village said, here is the special use permit for all the lots. Here's where I'm trying to change the plan that you approved. All I'm trying to do is change the plan that you approved. Now,
We did,
the
the
second
plan
part,
we approved, okay?
The plan-
Was not the one from 2009. That was approved, but that's expired, so that
well,
doesn't.
because you're looking at each time you come in, then it would be an expiration. So if Mr. Tesla, for instance, combined two lots and then didn't build for a year and a day, that would expire. I don't think we'd be here for that, but
See,
again, I understand. The second thing is, even though we are not going to consider the fact that the 2009 amendment granted 36 units, because we believe that is now irrelevant, we understand that you are still properly here as an amendment from the original that has lot 10 included right now in space with no use, but not dedicated. There is now no dedicated use because the dedicated, you wouldn't allow the dedicated use of 36 units until you made a finding that the declaration documents were changed so that the parking requirements of the tower were moved to lot 14. So we sit there in space right now. And it's still, I think we come here, if you don't want me to reference what happened in 2009, that wasn't, I'd want to know what happened in 2009 and this was better or worse than what other people did. If you don't want me to mention it, I won't.
well,
And we
I'm
can
just
do
looking
it
at
on
a
its
lot of
own
the
merit.
documentation that you put through refers to 2009. In 2009, it was this, in 2009, the exhibit G at the 2009 hearing.
Well, because it was
Everything
my,
is 2009, but that's all expired.
2009 was just the latest on this round, but I have every decision for you here if you'd like to see them. But note, even that decision, it starts out, I mean, you can all read it. It starts out, special use permit, 26 lots, 2A, 2B, 2C, 2D, 3, 4, and 10. 2A, 2B, 2C, those are the villages. All those other lots, all the fours, or I think all the tower residences, I believe. All of those are just different tax numbers. The tower has one tax number. The residences have a tax number. The villages have a tax number. The marina complex, the marina and this lot have a tax number. They are just different pieces of the overall permit. They're not individual. If you would have individual house lots down there and we cited them, you'd be citing every single owner of every single unit. Instead, that's just the way it's done. It's done because you have a master condominium known as now the Equidnet Club, and they have 7 or 8 sub-condominiums, one being the residences that have their fees to the master and their fees to the things unique to them. One to Carnegie Village, their fees to the master, the fees to them. One to the marina, the fees to the master, fees to themselves. They have just all different, that's how they're broken up tax-wise under the condo documents for how they are internally run. But they have to be considered as a whole for everything else that you do, certainly traffic and density and that's what you did. Now, I think it's okay for me, regardless of what happened in 9. Forget that I have any permission or don't have permission. When there's an ambiguity on how to determine how they're going to look at density, and I say the board, with James not chairman, found that did calculations on density on all of the lots. I don't think it's presumptuous of me to read those last decisions and say, this is how the board's going to handle it this time, because this is how the board handled it last time. And if you want to change your mind and vote and say, well, we're not going to handle it that way, I understand that too, but I don't think I should be criticized for coming and say, this is what you did last time.
Well, I think, and I'm just reading Mr. Gorton's petition from that 2009 thing. It was interesting because he, in about 2 seconds worth of words, explains the grounds for the special use permit / modification special use permit and his grounds for dimensional variance. And it's very simple to read and clear to go through.
If you're reading it,
And
that was what I read to you.
no, I know, I realize that.
So I can change the words. Petitioner's affiliated companies have approval for a multifamily resort complex
But
on the
he's
above
not
referenced
referring
lot.
to, the only thing he refers to in this whole thing, so as to keep it on the straight and narrow as to exactly what is being proposed, not as compared to what was proposed before. There were this many units in 2009. Now we want this. It's very clear, cut and dry.
Jim,
It's,
all
this
right.
is a vacant lot. This is what we want to do. And that's not what I got.
Okay, let me tell you what you did get though, right? Just hear me out. It says, said approval initially included approval for marina service complexes
Right,
on
right. You
lot
don't have
10.
to reread it, Mr.
But-
Spell.
But you say like I'm not being genuine.
No, I'm
He
not saying
said,
you're not being
this is what
genuine.
you approved so far.
No.
I am here to change it. Just
What we
now,
have approved so far doesn't exist anymore. It expired.
but it didn't then, and I wrote it exactly like he did, and you say that you just didn't. Back then, it was the Marina Services Complex,
Well,
and then it was parking, and he went right through saying, this is what you approved at first, this is what you
Well,
approved
but-
at second. He didn't cite, this is what you approved last week, because you didn't approve it yet,
wait a minute.
but all I did was include it.
So petitioner, this is Mr. Gordon, petitioner seeks a modification of the existing special use permit to allow the now vacant lot 10 to be utilized for 36 3-bedroom, single-family units as part of the existing resort complex. Fast forward. This proposed project is not additional units. Applicant seeks to replace the approval of 36 units contained in 3 buildings, seeks approval to build 28 individual resort units. 6 of the units are duplex units and 22 of the units are single. And then you go on to 2009, they're not replacing anything, okay? Applicant seeks to replace the approval of 36 units.
Well, because there was 36, under your rules, it's expired. So I want to replace what you did then
Why
with
not just
24
tell,
units.
why not just tell the board exactly what you want to do versus?
I want to have
add all
28 units. It says that, Jimmy.
that? Go ahead.
I just want to make sure we.
Yeah.
Clarify. Not that it hasn't been.
No.
The whole umbrella, the Carnegie community is under one umbrella, and that's what the special use permit is.
Yes.
As a resort.
As a resort, right?
Right.
So where we're at is you cannot pull another one,
Right.
apparently, but it has been acted upon, so technically it's still being acted, right? Because it didn't stop, it just didn't develop a portion of it.
No one's saying that the original special use
Modification.
permit is.
No, I get,
Has expired. There was a modification to that.
yes.
That portion has
So,
expired.
so
how else would you come back? Reapply for a new modification to? an
No, you
expired
can modify
permit?
this permit and provide us with new data, something a little more simple and palatable to me that shows that this is what we're proposing. I don't even remotely want it compared to 2009.
You mean the 36 units?
Right.
So even though they're coming back
exactly.
with less density, less units.
But we're all
Whatever they
human
wanna
beings. It's
propose,
saying,
but-
ladies and gentlemen of the jury, disregard what he just said. You're gonna, we know it's out there. If I come here next week without it, we still know it's out there. You've asked me not to reference it tonight if I put it
There are
on.
members
That's
on this
okay.
board who were not here in 2009, so they have no idea.
But they individually should be able to say in their own vote, not what the chairman wants, in all fairness,
No,
they
no,
should be
no.
able to say, even if I agree that that modification in 2009 has expired, I would like to see what was approved then, because that may shape my opinion now. And it might be a 1% chance or 80% chance. But if they want to look at it, it's there for them to look at. And if they want to paint it black, paint it black. But in all fairness, I think what was there before and what was approved, and as well as what it could be. It could be a Marine Service Center. And I think always in zoning, we should consider not only what is before us, but what it was or what it could be. Now, maybe what it was, I argue I could still do to 36 and you say it's expired. That really wasn't even on today's plate. But what it could be, that's on today's plate.
Mr. Chairman,
So the alternative opposed to modifying now is starting a new one, just.
No, it will always be a modification. to a
Yeah, but I
special
mean,
use permit.
I'm kind of,
That's
what's
where
the
we're at.
difference?
We're kind of in the middle.
Mr. Chairman, I would move that we close this hearing unless there are butters or interested parties and vote whether we're going to vote whether or not we accept the fact that it's continued or that it's expired.
is there any prior?
And then the
Precedent
petitioner
on
would
this?
need to reapply to the board for what the petitioner seeks.
Can I just clarify, are you saying the modification?
Yes, correct.
But if you vote the modification is done, it's still here on the modification of the original. And my petition is still identical.
Going back to the same thing, I guess. is my original
It
question.
just,
But
in
it's-
my,
but everything gives you the indication that you're trying to modify a modification.
Correct.
You're trying to modify a
okay,
modification.
and if you vote that I can't do that, we still are in the same place. We're not in go home,
No,
take your box,
no, that you can still apply to modify the special use permit, but not
this is the application.
modify the modified one because that modification
expired.
expired.
Yes.
It's not what it says. You're misreading my
You're
application.
saying it didn't expire because it's still in use, it's lumped under the whole Carnegie.
I'm saying, okay, we're being a dead. Our application says I'm seeking to modify the special use permit that there's not 8 special use permits. There's the special use permit that
Totally get
started in 01, 03, and 05. And my new petition, just like this petition is gonna say, I want to move that petition. What you want me to do is to say, I hereby covenant that I will not bring up to the attention of the board members that in 2009 you granted 36 units, which I thought I was doing
That has
very
expired.
genuinely. All right, if you vote that that has expired, then the board, to me, the only difference is this a project I should grant, yes or no? Does it meet the criteria, yes or no? We shouldn't either consider what happened in 2009, or we should consider what happened in 2009. But either way, we have the same criteria of A through J. It's still if you're trying to say it's not a resort anymore,
No,
and
no,
it's
no.
an Article 7, Section C apartment complex, only considering this 6-acre piece, then
So-
that's a whole different thing.
So even the abutter notification went out. Quitting the club seeks to amend a previously approved special use permit 2009 to develop 22 single, okay? Everything I read in here is related to that modification of 2009.
You know, we don't write that, right?
I know you don't write that.
And we know that
I know you don't write
Mike's
that.
opinion's a bit different, because I will promise you this, I have my petition, and it just says seek this to amend the special use permit previously granted on map 26, 2, 2A, 2B, 2C, 2D, 3, 4, 10, and H. And I even go into the history of how it starts and how it was a hotel and how it began in.
Mr. Chairman?
Yeah, go ahead.
It, is it undisputed that the last amendment to the special use permit was made in 2009?
Yes.
And special use permits expire after.
That was a
year.
modification to a special
Yeah,
use.
yes, yes. And
And wow, it's up to everybody's opinion
Can I just?
whether that modification expired.
It's not, it's also not disputed that the last modification was July of 2021. In July of, to my knowledge, no one's been here since July of 2021. But
But
when
we're
I,
talking just lot 10.
well, although lot 10 is listed on all of those petitions as part of the special use permit,
I understand.
you are correct that the use of lot 10 was last addressed in 2009.
I'm going to give this petition 15 more minutes of debate, and then we are going to, I'm going to make a motion to continue it. That's,
Either way, maybe you should let council weigh in on it.
wow. Yeah, is Mr. Gavin on? Kevin? There he is. You muted, Kevin. There you are. Go ahead, Kevin. Is he frozen?
Yeah, I think it's,
No,
There you are.
Fit.
All right, now we got you.
okay. I don't, is there a specific question or? My
We're
internet
sort of in a
working?
quandary on this whole thing.
I mean, I there's a lot going on here. I don't know what you expect me. I can't really just tell you what to.
No, I get that.
My understanding, this is to modify the modification from 2009. I
Say
can
that
hear.
again, Kevin?
I mean, it was my understanding that we're modifying the decision from 2009. Now, court's making the argument that you're really, the issue is modifying the 2001, I think he said.
Yeah,
original?
well, my argument, at least mine personally, is that the 2009 modification is irrelevant because that would have expired.
Right. I think that's a valid point.
And it still would be a modification to a special use permit, but not the modification of 2009, correct?
Right. And to argue, I mean, the ordinance says if it expires, it's null and void.
Right. Okay,
So how can you piggyback on something that's null and void?
right. Okay. Thanks, Kevin.
There is no such thing as a 2009 special use permit.
We just said modification. We said the modification. That's exactly
2009
what
was
we
a
said.
modification.
That's
of the
exactly what we
original.
said. You're
I
trying to
agree.
modify a modification. And I said that
Modify
earlier.
the only permit we have that's been modified 17 times. Just trying to do it 18.
And Mr. Chairman.
But this is now the third time for lot 10.
It's included in every petition.
It's the third time for lot 10.
Fair enough, the specific use for lot 10, counting the original, it's the
Thank you.
fourth.
And
Mr. Furell?
Mr. Chairman, the previous plan we've been shown with the 36 units, was that the 2009?
That was the
iteration?
2009.
Okay, gotcha.
That was put
Okay.
in by Michael, not by court,
Okay, thank you.
in fairness, right? I didn't show you the 2009 plan. I showed you the decision.
Absolutely.
Thank you. Why is this becoming an issue now and wasn't when Mr. Chappelle came to us previously where we said to him, you need to get planning approval? Why is
Because it
it a
just
different situation
Came to
now?
our attention. There's a number of things that were brought up by our planning department.
So these were as a result of the report from the planning department.
And again, in fairness, it doesn't matter that it's happening. It matters that you don't think I was pulling something. We
No,
met
no,
with the
that's-
planning
that's
department
totally
before I
not
got
the
here.
case.
Before I got here, we knew it was going to be an issue. I stood here and said, guys, this is how it can be. What do you want me to do? You said, go to the planning board for advisory opinion, go design review, of which we've done and hasn't even had a person show up to say anything other than clap. They were very positive recommendations. And then all of a sudden we get completely derailed 2 days ago with where there's a difference between modifying the original permit and modifying 9. I think the only difference is whether my fallback is the old or new. I clearly have your opinion on whether my fallback is now a vacant lot
Right.
that has been dedicated 3 times and now is not dedicated at all.
No.
So I have a right to come here and go, hey, I got this 6 acres,
Start from square one,
But
and I'm
it's-
not saying
but I am
that.
square one. I'm still, I didn't come in without full petition, full engineer, full everything. I mean, there are certain things, the probably only thing I was piggybacking is if this board heard from a traffic guy in 2009 that 36 units did not affect the traffic, are you going to exercise your discretion to ask me to get a traffic report? And if you said yes, I would have said, please continue 1 month to do that. They're $5,000 to find out a clamshell roll head, has 3 cars on it, but I'll do that for you. But that's the only piggybacking I was due. And I still am going to ask you to do that, even though you say you don't.
But Mr. Chappelle.
You don't have to
let me
rely
just
on
tell
it.
you, I'm looking at all of your explanations, your proposed use of property, dimensional regulation requests and comments. These are yours, correct? These are not the
I
town.
pointed out
Okay.
both before and
So,
after
all right,
planning board,
So-
PUD and rules here.
right. And there are so many things in here that refer to that 2009 lot coverage. In 2009, you go on about all that. It's not simple. This is the lot coverage we're proposing right now.
Jim, what I thought I was doing was bringing the board that wasn't here up to speed on how it was handled in the past. I didn't expect the guy that sat at the meeting wanted to change it. And chairman the meeting, in fairness. It's okay if you do,
Distance-
anybody can change their mind. I
Distance
just didn't see
between
it.
buildings, but again, Mr. Chappelle, I mean, I'm only doing this because that's what our ordinance states when it comes to special use permits, okay? In this case, it's a modification. You're trying to amend a modification
No, trying to
that
amend the
doesn't-
original.
that doesn't exist anymore.
Okay, it doesn't really say that.
Mr. Chairman,
And I'm not saying that,
Either way,
It's up
we
to
can't
the
take up
board.
everybody's time. I don't know what you want me to do right now. Why don't you refer it to Kevin? I'll either come back with an amended,
my personal opinion would be continue it, get Kevin's opinion on it. That's my opinion.
Mr. Chairman,
Yep.
if I could, it seems as though the solicitor already weighed in that it's expired and the petitioner needs to come back and start over. It's expired.
Well, I agree with that. And then I agree to disagree because I don't think it's fair to the applicant, because the applicant can come back and apply for a modification to the original special use permit and propose just what he's proposed.
I agree.
To have him have to reapply versus modifying his application, which could be done.
and remember, we've already gone to, nothing
Yeah.
would change at the design review or planning board about whether septic was adequate and drainage was adequate, but a new one, if it has to go back to the planning board, can you take a planning board recommendation from the exact, nothing's changing in the
And it
petition.
may just be some language change period, just to satisfy the board.
I mean, Mr. Chairman, if I could,
Yeah.
I'm concerned about setting a precedent. If it's expired, it's expired. I mean, Lot 10 is a separate entity from 2009. That's expired. period.
It's a separate entity, but it's part of the condo. It always.
I
has been.
understand that, but
And I
to
don't
just
know
tack it on
If we
to
ever,
continuances from all of these years, all the way up to 2021 with nothing built on it.
but I don't know if we have
is-
any precedent. Do you remember any? Because I don't, that we have a special use permit, then a modification of a special use permit, and then something. So it isn't a precedent thing. Carnegie is its own beast.
Well,
There's just nothing
I
else
think-
like it that combines 8 lots under one umbrella.
I agree, but I think in this particular case, it's the first time, at least in this member's memory, that I've seen something this dense proposed down there. That's
Second
kind of
time.
That's kind of the difference.
At least the second time. Since it's less dense than the other one, it's just, that makes it.
Just saying, so. My opinion would be is that we continue it in all fairness to the petitioner rather than have him reapply or any of that, because again, I agree, nothing's going to change. Nothing's going to change here at all, other than some language. And we'll get the solicitor's opinion on that as well.
I will substitute the attachment, which is my narrative trying to bring everybody up that references 2009. The petition itself will probably be identical. The narrative will be substituted to eliminate references to 09, although I
I
think.
would
it's
try to
still
make
legal
it
for
as
me to-
simple as possible.
Well,
Mr. Gordon's
that's where the
narrative
references
in
are.
there was very simple. You know,
But I had to include what happened to him. So I thought. And that is what makes it 2 pages and not 1.
Can I address Mr. Chappell?
Absolutely.
I have no doubt that you're being upfront with us. You know, I don't think you're trying to cover anything or,
No, that's first
Nope,
and
not
foremost
at all.
important.
but when I look at a plan that was from 2009, and then, all right, that plan is being modified to something else. I think personally, I would ask, and some of the other board members may have more experience with this than I do. If a traffic study, virtually everything has changed since 2009. So I would question, is a 2009 traffic study relevant in 2022? Are environmental studies?
I agree. And we, so you
So-
didn't know,
so-
but we had everything new except a traffic study.
Hang on.
Right,
Mr.
so,
Sullivan.
so.
We weren't relying on you.
So personally, there's not very much value for me of knowing what the 2009 plan was. The 2022 plan, it would be easier for me to understand and sort of stand on its own feet, just to come in and say, this is what we want to do, 20-something units. Here's the supporting data. I'm not too interested in what happened in 2001 and what Mr. Gordon did and, what the Pilgrims figured out, all that.
Did a good job.
It's too.
I'm glad
hard.
they did it. There's some, okay, and
So if we could just get a 2022, cool. That.
like, Jim, I don't know if you remember, but even though he said, I don't think I need a variance for the south side of lot 12 because it appears to me to be a side yard, but to the extent I need a variance, granted. And then when you did the petition, there was no variance. I took that as the board thought that was a side yard, which is what Vernon said and what court agrees. Mike put in his memo, they asked for a variance back then, so they must need a variance now. They asked for a variance then, and it wasn't voted on and specifically not. So I was using that as at least some legal precedent, which I would all the time. You just don't want me to hang my hat that because you did 36, you got to kind of do 28. I get that. I argue differently because that's what I do, but I get that.
So what do you want to do?
Well, it seems with everybody in the room, I didn't get lynched, I think, and we wouldn't finish tonight.
No.
So I would suggest that you continue this. We can, in fairness, let Kevin weigh in.
Yes.
I will, at the very least, file a supplemental
Okay.
addendum so that it doesn't reference, and I'll make it clear that the board thinks that. I have to put I reserve my right on that because that's a, right? I can't be giving away rights. But I get that you're going to preserve that way. And part of the vote would be that that happened. And if there's an appeal, that would be one of the issues that would be addressed.
Could I just ask a question?
Yep.
Because it's been talked about, and I'm not intimately familiar with all this whole development over the decades. But it was mentioned that this lot 10 is owned as a condominium that's part of the overall resort development. If I'm going to be asked to weigh in, I'd like to maybe know a little bit more about that. I mean, is it, who owns this? Is this a separate lot? Who owns it? Is it a condominium unit?
Right, that
all the
was
lots are
discussion
separate.
before, Kevin.
It is a condominium unit?
Well, there's nothing there now. I don't
Yeah, there's
know.
nothing
I
on
haven't
it.
seen any of those docs.
Right, but maybe court can explain, is lot 10 a condominium unit, part of an overall resort development? Because I'm not aware of that.
I'll
I
have to
thought-
track it
I
all
thought lot
down.
10
It's owned by the Aquidneck Club and taxed to the Master Condominium Aquidneck Club.
That's kind of why we're continuing this. Kevin, hope that you can weigh in on some of that between now and the next meeting.
I mean, I don't have all these facts, and I mean,
Well,
I mean,
that would mean a meeting with me and you, that's all.
well, I
Show you
mean,
the file.
I don't know if it's a very complex thing. I'm supposed to figure all this out and decide what the board should do. I mean, it's pretty straightforward just in terms of modifying the 2009.
That we,
Modification.
Kevin, that we know. It's pretty
I
straightforward.
know that, but I mean, I don't know what, okay, yeah, you want me to weigh in, but I'm not quite sure what I'm supposed to weigh in on, but okay, we'll figure it out.
All right,
The only issue that I see on doing it as, even if I came in and asked for a special use permit on lot 9, the only issue I see is to still you have to collectively look at it as one of the 6 pieces of Carnegie. Because if you
that's an
don't,
argument for the future court.
but that's the.
But I think
argument,
it's up to
right?
the petitioner to establish that fact that he just said.
Well, I have 7 decisions that say that.
All right, that's why. All right, can I have a motion to continue?
Well, Mr. Chairman, I would just raise the question, do we want to ask for butters or interested parties to weigh in on tonight's testimony?
No,
Okay,
not till we get to that point one way or another. But
okay.
Thank you.
I would move that we continue the petition to our regularly scheduled meeting in March
17th. Can I have a
on
second?
the 17th.
Second that.
Motion been made and second to continue the petition of Aquidneck Club, Inc. to our regularly scheduled meeting on March 17th. All in favor?
Aye.
Opposed?
Thank you.
Thank you, Mr. Spell. We'll hear a couple. Next item on the agenda is the continued petition of Newport Solar, Inc. And Joseph Studwick.
Hello, I'm Eric Martin of Newport Solar, representing Mr. Studlick.
Yeah, and just for the record, Eric, first of all, could you raise your right hand?
Yes,
Swear to tell the truth?
yes.
Full name and address for Teresa, please.
Eric Michael Martin, 9 Tyler Street, Newport, Rhode Island.
And just for the record, yeah, we do have a letter on file from Mr. Studwick that says you can speak on his behalf.
Great,
Thank you
thank
very
you.
much.
Mr. Studlick and Newport Solar did send an email out just requesting that we do actually file for another continuance based on some errors that we have in the drawing at this time.
Okay,
And if I could pursue some clarification on how we might modify those and
Sure.
represent them accurately. So
Okay.
right now we have I think 42.5-foot setback from the northern boundary. We want that to be 20 feet, which is, I think, the minimum allowable setback for this structure.
will it fall into the allowable setback?
So a question on that. So is the setback based on the actual foundation of the unit or the extent of it? Like on a house, for example, is it the foundation of the house or the rake of the house?
The rake of the
The
house.
rake.
It's the rake of the house.
Right,
Okay.
Up to, you can have it up to 18 inches on a
Yeah.
house.
Yeah. right.
Right, I see what you're saying. So the rake could overhang 18 inches.
Yeah, anything
Right.
Beyond
over
the
that. Yeah,
foundation.
Yeah.
Anything over that.
it would. You would
Gotcha.
have to meet.
So we just have to make sure it's
Within,
within,
But that's specific to a building and not specific to any other kind of
so
structure.
that wouldn't apply to like an accessory structure.
I think it's specific to eaves.
Okay,
There's a few like eaves, cornices.
Yeah.
It lists in the zoning code what can be projected.
okay,
Um,
I see.
It doesn't say solar panels.
Okay. All right, that sounds good. I think for now we'll just.
okay, so you just want to continue it?
Yeah, and we'll just modify the drawing.
Okay.
To be to 20 feet. And
Could I have a motion to continue? the
Mr. Chairman,
petition?
I would move that we continue this petition to our regularly scheduled meeting of March 17th.
Second? Second, motion been made and second, continue the petition of Joseph Studwick and Newport Solar to our regularly scheduled meeting on March 17th. All in favor?
Aye.
Opposed? Thank you very
Thank
much, Mr. Martin. Okay, one more and then we'll take a break. We'll get something done tonight. The next item on the agenda is the petition of Frank Fasaro and Lindsay Viveris. Here they come. And you have been sworn in already.
Yes, we have.
So the first thing we have to do, because we got all the new information, so I have to ask you if you formally want to request to modify your original application.
Yes, we do.
You do, okay. Could I have a motion to accept, to allow the modification of the original application by Frank Fasaro and Lindsay Viveris?
So moved, Mr. Chairman?
Could I have a second?
Second.
Motion been made in second to allow Mr. Fasaro and Ms. Viveris to modify their original application. All in favor?
Aye.
Opposed? Here we go. Okay, so I see you went back to the architect,
Design.
right? And for the record, now looking at a request for a 4-foot front yard variance, 20-foot rear yard variance, an 8-foot side yard variance, and a 5-foot side yard variance, correct? That's what the new one looks like.
I think there may be a lot coverage.
Yeah, I haven't got to the lot coverage yet.
So the variance, the only variance that's going to be changing, or setback, excuse me, that's going to be changing is the front yard with,
Right,
with
To
the
the
porch.
4-foot.
The other ones I amended because when we had gotten approval from the board back in 2020, that was based on just me doing a drawing and guesstimating. Then we had a actual survey done, so.
Right. And the actual original, the actual proposed additional lot coverage is 2.3%. You're currently at 41.48%. You're requesting an additional 2.3, which would give you 43.77. The variance request is 23.77, but the actual additional is only 2.3.
Yes, sir.
And I see that the half story now shows 4-foot knee walls, not an 8-foot story.
Correct.
Correct?
Yes, sir.
Okay. And last, very nicely, thank you very much for that.
You're welcome.
That shows the average lot coverage of everything around you.
Yes, sir.
Okay. So that being said, I will defer to Ms. Horowitz. Sure, absolutely. And that's all about all that's changed from the original petition, right?
Yeah. Yep.
And it will be under the 35-foot height.
Yes, yep, 34.5.
Right. Now, for the record, I think you might have previously testified to this, is the setback requirements are the requests. The rear and two sides already exist.
Yes,
You're just going up.
yes,
You're not going out.
correct.
It's just the 4 foot in the front to put the little,
Porch.
of which, as I drove by the other day, there are others in the neighborhood with similar things.
Yes, sir.
Questions, Mr. Borden? Didn't think so. How's it look to you, Sue?
It looks good. I installed, and I suppose it's not for me to worry about it, but your average grade calculations, I'm still saying to you, get a survey, get those grades calculated and make sure that you're,
They were done. They're included.
so.
Yeah, there is an elevation certificate.
We have an elevation certificate.
Oh, okay. 'Cause that
Great.
would be my concern, because
Yeah.
the town
No, no.
can ask you to survey the peak.
Yep.
during construction.
So we have the current peak surveyed. It's at 21.
That doesn't matter.
I know, but based on what it is at 21.9, so by the new plans, that peak will be at 34.5.
That would be my concern.
Okay. Questions, Eric? Eric, any questions? No?
Looks good.
Mr. Furell, any questions?
No, sir. We do have a letter in the file.
Oh, okay. You want to read it?
This letter memo from Susan Panaccio. I understand my neighbor, Frank Fusaro, requests for a zoning variance, or is it variance? Anyway, has been continued to February 17th. As a 36-year, year-round resident of Riverside Street, I have no objection. Susan Panaccio.
Okay. Are there any other abutters or interested parties to this petition that want to state anything? You want it? Oh. Do you want, so come on up. Yeah, you have to come up. I'm sorry. I do have to ask you to swear to tell the truth
Hi, I swear to tell the truth.
and your full name and address, please.
Riverside Street.
Okay.
These are my neighbors. They're fabulous. They would never do anything against anything. They're just wonderful, kind people. And I'm very happy and fortunate to have them as neighbors. And I just love them. They're just good people. And that's our community. That's what we want to do, support people that are part of the community, help people when they're in need. And these are the people. And I approve everything that they're doing.
Thank you very much for coming out. tonight.
Thank you and have a great day and be well and safe.
Thank you. Anyone else? Come up, please. You're the whole neighborhood here. Swear to tell the truth
I do.
and your full name and address.
Denise Viveros, 287 Riverside Street. And I also own 271 at Riverside Street, which is just 2 houses down. And I just want to state that Lindsay and Frank are just wonderful people. They love their neighbors, their neighborhood. They take pride in their house. And unfortunately, after being out of their home for over a year due to the fire, they are just really want to build a lovely replacement home for themselves
Thank you.
and improve the neighborhood.
Thank you very much.
Thank you for
coming
your
out.
time.
You want to get up? No, you're good. Okay. All right, seeing as how there is no one else, Frank Fusaro and Lindsay Viveros are before the board for tax assessors map 15. lot-
Chairman,
What?
could we just check?
Oh, yeah,
on the Zoom?
that's right.
Yeah.
Keeps getting about Zoom.
Yeah, if you're using the Zoom app, you can use the raise hand function, and if you called in, you can use *9 to be heard. We're good.
No one, we're good. Okay. All righty, Frank Fusaro and Lindsay Viveros are before the board for tax assessors map 15, lot 59. They did testify earlier to the special use.
I'm sorry,
criteria.
sorry to interrupt, Jim. Oh, do you already got the testimony on the special use?
I thought I did it last time, Kevin, but I'll
yeah.
do it again,
No,
just.
I don't have my notes. I just don't remember.
Yeah, I'll do it anyway. So because you're a substandard lot of record, I have to ask you this question. So let me get to that section. So if we allow this, would it still allow adequate space for fire protection?
Yes.
I hate to say that because I know. you have. Would it provide adequate light and air between buildings still?
Yes.
Would it alter the character of the neighborhood or adversely affect neighboring properties?
No.
Would it create lot coverage and setbacks less than the average lot coverage?
No.
Would it impose a substantial detriment to the public or to your immediate neighbors?
No.
Thank you. Okay, Frank Fasaro, Lindsay Viveras, again before the board for Texas, is map 15, lot 59, seeking a dimensional variance and a special use permit for a substandard lot of record for the purpose of reconstructing their home. They're seeking a 4-foot front yard variance, a 20-foot side yard variance, an 20-foot rear yard variance, and an 8-foot side yard variance, and a 5.5% foot rear side yard variance. The rear and two sides already exist. This would be for the addition going on. They're also seeking a variance of 23.77% lot coverage. It's actually only 2.3 more than what already exists. So, Mr. Borden.
Mr. Chairman, I'll take the special use permit for substandard lot of record first. Petitioner walked through all the criterion and they've met the ordinance, so I vote to approve. In regards to the dimensional variances, the lot itself is 3920 square feet in an R10 zone, which is extremely substandard. Petitioner has a hardship to deny the dimensional variances for setbacks would amount to a hardship more than a mere inconvenience. The fact that the lot coverage request variance is minimal is a testament to the petitioners for such a small lot. So I vote to approve.
Thank you. Let's see, we'll go with Mr. Fiorell.
Mr. Chairman, I vote to approve the special use permit. As stated, the applicants have met the conditions for a special use permit on a substandard lot of record. The dimensional variances, I also approve, given that they're replacing a home with just a minor difference in what was there before, is also laudable, given that people tend to want bigger and better. So I approve both.
Thank you. Mr. Reposa?
I also vote to approve both for reasons previously stated by my peers.
Thank you.
Did a great job.
Ms. Horowitz?
I vote to approve both for reasons previously stated.
Thank you. Chairman also votes to approve both the special use permit and the dimensional variance and lot coverage for reasons previously stated by Mr. Borden. So you're all set. Now, I have to say, I know you were very disappointed last meeting, but now do you see why?
Yes,
Okay,
thank you.
not a problem when otherwise it would have been very difficult. Okay, so
Thanks.
good. Well, good luck. Best to you. All right, we're going to take a 5-minute break. And when we come back, we'll be hearing the petition of David and Kathy Clark.
We had a conversation with Mr. Stephen, right?
Well, I saw him, actually, he sent his number. And he texted him. He knew me, but then,
You want me to set up a text with you?
just some of his number. I didn't see it.
What's your number? 3199.
Good now. You gotta save it.
I'll just say hi,
Okay.
then I can.
Beat me.
Never answered my call if you don't say.
Cool. He's a proposer. He's a proposer.
What's you, is that? right?
That's mine, yeah, he's, oh. Too many moving parts. You know, I hope he's in photo, so I can check the box. I put the field test and then got a piece of audio. What sounds like you do like a big teleconference. It's in a friend. So that was a week. It took a week. It took a week.
Yeah.
You know what I mean? Like, you want to have, you know, social, like, yeah.
And it's not with the kids.
Yes, that's what I did for the past month. For the 7 weeks, we go to 6:30. It's next day. You know. The three of them. Twins, 3.5. So 2 years. Oh, she's like a kid. It's like a survival swim.
So they learn to
It's the
float.
whole, yeah.
Oh, that's. Have you got a pool?
Putting one in. How you doing? I'm tired. How are you?
Yeah, up on the rocks. Yes. Hi, how are you?
And Kathy Clark. Clark's here. Okay. What's that? They are.
Yep.
Okay. Let's, there he is. You got him up?
Yep.
Hi, Mr. Clark, are you on? I don't see his video.
Hi, can you hear me?
We can hear you. We can't see you.
You can't see me. Okay,
No, you gotta turn your video on.
I'm doing that
There
here.
you are. Oh,
Yep. Okay.
we had you there for a minute.
Is that on now?
Nope, not yet. You were on for a second and then you disappeared quickly.
Okay, how's that?
Ah, there you go.
Okay,
Okay, Mr. Clark, could Raise your right hand. You swear to tell the truth?
I swear to tell the truth.
Okay, could you give your full name and address for Teresa, please, for the record?
My name is David Clark and my address is 28 Canton Ave.
Okay, Mr. Clark, why don't you explain to the board what you'd like to do?
Well, we'd like to build a 8 by 16 covered porch on the rear of our house. It's part of a modification that we're looking to make, as the current home has no interior access to the basement where the laundry facilities are located. And in making that possible, which is under an existing overhang of the roof, we'll be losing some natural light and ventilation with some window changes. And so part of this then is to add a sliding door in place of the existing passage door and enlarge the current porch to a smaller, a small but larger covered porch on the back of the house.
Okay. Let me see. I take it this is new construction, is it? Or
This
no?
deck, this is an existing home. We purchased the property in 2019.
Right,
So the plans that I submitted show the existing house and, foundation and so on, and then the proposed design of it.
I'm just kind of looking at some aerial shots. It appears there's a couple of neighbors that have, looks like smaller decks or decks similar to what you're proposing. Does that sound correct?
Correct, yes. So some of the neighbors do have similar porches and so on the rears of the houses, which also have similar setback dimensions that I'm proposing.
So let's see. So really, it's just the rear yard and a lot coverage request.
Correct.
Correct?
Mr. Chairman, are we also looking at a substandard lot of record, given that it's 4,000 square feet?
Yes, we are. Well, we should be. Is there a substandard lot of record?
Yeah.
It is. It's not marked on this.
It's technically on the map that on the last page of the application, it shows it as one lot, but Mr. Clark actually, it's 30A. But that lot is kind of divided right in the middle.
Okay.
There's another one under the same
Yes, the
ownership.
property, we do own the lot behind the house, but they were purchased as, the house and the 4,000 square foot lot was one purchase. And the rear lot that fronts on Berkeley Ave was purchased separately.
So interesting, so is the deck going to encroach more on your own lot?
Yes, the deck will only, that's the setbacks that I've noted. There currently is 20 feet from the very back of the house to the existing property line. And the 4x6 porch going into the existing rear door would be enlarged to an 8x16 covered porch.
Right, but the lot, so where that deck is in the rear, the next property behind you is yours as well, correct?
That is correct. It's a separate lot. It has a separate tax bill and actually has an approved septic design for it.
Okay. So because of that, I do have to, you would require a special use for substandard lot of record. So I do have to ask you like 4 or 5 questions. So if this were to approved, would it still allow adequate space for fire protection?
Yes,
Would it still provide adequate light and air between buildings?
yes,
Would it alter the character of the neighborhood or adversely affect your neighbors?
no,
Would it create lot coverage and setbacks less than the average lot coverage and setbacks?
No,
Would it impose a substantial detriment to the public or to neighbors?
no.
Okay, thank you. The board have any questions for Mr. Clark? Sue? Eric? All right, I just have to ask for abutters or interested parties. Is there anyone here that wants to speak on that? No. Mike, anybody on Zoom?
If you're using the Zoom app, you can use the raise hand function to be called on, or if you called in, you can dial *9.
No one?
Nope.
Okay. All righty, so David and Kathy Clark are before the board under tax assessors map 3 lot 30, seeking a 8-foot rear yard variance and a 10.9% lot coverage variance, although it's only an additional 2.6% over what they have now, and a special use permit for substandard lot of record. Mr. Borden.
Mr. Chairman, the petitioner walked through with the chairman the substandard lot of record special use criterion, and it meets the ordinance, so I vote to approve. In regards to the lot coverage, the lot itself is 4,000 square feet, which is extremely small. Existing lot coverage is 28.3. The additional 10.9% may seem excessive, but for a 4,000 square foot lot, it's reasonable. So I vote to approve. In regards to the dimensional variances, the setback variances, in my opinion, they're reasonable to fully enjoy the permitted use of the residential property. So I vote to approve.
Thank you very much. Mr. Furell.
Mr. Chairman, I also vote to approve the special use permit application for a substandard lot of record and the lot coverage variance and the rear yard dimensional variance for the reasons cited by Mr. Borden.
Thank you very much. Mr. Reposa. Thank you. Ms. Horowitz. Thank you very much. The chairman also votes to approve for reasons previously stated by Mr. Borden. So been approved, Mr. Clark.
All right, thank you very much.
Have a great evening.
Thank you.
Okay, the next item on the agenda is a petition by Todd and Sandra Smith seeking it says seeking a dimensional variance to construct a single-family dwelling with garage. Basically, it's to construct a home on a lot that has no frontage on a public way. They online? Oh, why don't you come up? You can get Mr. Clark off, Mike, if you would like.
Oh, yeah. Never mind, you left.
Okay, could you raise your right hand? Swear to tell the truth? Yes. Full name and addresses individually for Teresa, please.
Sandra Smith, 36 Grass.
Todd Smith, 36 Grass.
If you could speak, try to speak into the microphone.
Yeah, if you just pull the mic down a little bit, it's probably better. Is it? Yeah, there you go. Okay, so tell us what you want to do.
We were just trying to get a building permit to build a new home, and
Right.
we have 2 roads that go into the property.
Right.
And I guess it didn't meet because it was the dirt roads and they're not approved roads on the island.
There are no approved roads on the island.
And that's why we're here.
I say that jokingly because this is what happened. So just looking at this, other than not on a public way, of which there are, you don't require any other variances. It looks like a fairly large lot. You don't
Yes.
need it. You meet the lot coverage, meet all the setbacks and everything else. It's not a public way, correct?
Yes.
That's what I thought. Anybody any questions? Didn't think so. Just have to ask for abutters or interested parties to this. But Claude's sitting there going, there are no.
If you're on the Zoom app, you can use the raise hand function to give public comment. And if you're calling in, dial *9.
No one. Okay. Being said, Todd and Sandra Smith are before the board for tax assessors map 74, lot 18A, are seeking to construct a home on a lot that does not front on a public way. Mr. Borden.
Mr. Chairman, to deny the petitioner the right to use their property to build a home would amount to a hardship more than a mere inconvenience. Just because it doesn't front on a public way is no reason to deny the petitioners the right to build their home. So I vote to approve.
Thank you very much. Mr. Furell.
Mr. Chairman, I also vote to approve for the reasons cited by Mr. Borden.
Thank you. Mr. Reposa.
I also vote to approve for the reasons cited by Mr. Ford.
Thank you. Chairman also votes to approve for reasons previously stated by Mr. Oh, I'm sorry, Ms. Horowitz.
I vote to approve for reasons previously stated.
And as the chairman does as well, for reasons previously stated. I'm sorry, Sue.
It's okay.
You know, it's been approved. Sorry I had to come all this way for that, but
That's okay.
there's not much we can do about that.
Thank you very much.
All right, have a good evening.
Have a good night.
All right. Let's see, next item is let's continue. Now we have the petition of Rebecca and James Sattel, seeking a dimensional variance for a rear yard setback and a special use permit to construct a 12 by 12 sunroom addition to a single family dwelling on a non-conforming lot of record located at 15 Settler Street.
Hi,
Raise your right hand, swear to tell the truth.
I swear.
Full name and address for Teresa, please.
Rebecca Sattel, 15 Settler Street, Portsmouth. I threatened my husband if he didn't come with me, I was going to start off by telling a few jokes, and he got really nervous, so I said I wouldn't.
Did he
do it.
come?
No. He said, watch me on Zoom.
Okay, Mrs. Sattel, why don't you go ahead and tell us what you'd like to do?
Okay, so we live, and I did not know this till I started this process, on a non-conforming R20 lot. It's a corner lot, which is 9,000 square feet, and it has a shallow rear yard. The previous owners had obtained a dimensional variance to build a 16 by 20 foot deck. We're going to be taking that deck down and putting up the sun porch, which has a smaller footprint. So now we're 18 feet from the property line. When we put the sun porch on, we'll be 22 feet from the property line. And this also reduces the lot coverage by about 3% to 20.7%. And also there's a fence on our property between our yard and the neighbors. So that kind of provides some.
So basically, you want to remove the deck,
Yes,
put on a smaller porch,
yes,
reducing sunroom.
Yep.
And reduce your impact on
yes.
everything.
It's a win-win, right?
Okay. Let me go over the special use criteria for
Okay.
substandard lot of record first.
Yep.
Okay, would it still allow adequate space for fire protection?
Yes,
Would it provide adequate light and air between buildings?
yes,
Would it alter the character of the neighborhood or adversely affect your neighboring properties?
no,
Would it create lot coverage and setbacks less than the average lot coverage and setbacks of adjacent properties?
no,
Would it impose a substantial detriment to the public or immediate neighbors? Do we have any questions from the board? Sue, any questions? Eric? No. Okay. Do we have any abutters or interested parties or the applicant's husband on?
So if you're using the Zoom app, you can use the raise hand function or dial *9 if you're calling in.
Okay, seeing none. Rebecca Sattel is before the board for tax assessors map 19 lot 68. seeking an 8-foot rear yard variance and a 20.71% lot coverage variance. The lot coverage variance request is actually 3% less than what they have now, and the setback is actually less than they have now. Mr. Borden.
Mr. Chairman, again, I'll take the substandard lot of record special use permit request first, and the petitioner walked through with the chairman all the criterion, and she has met the criterion, so I vote to approve. The dimensional variances are minimal, and to deny would amount to more than a mere inconvenience. It's a reasonable request for residential use, so I vote to approve.
Thank you. Mr. Furell.
Mr. Chairman, I also vote to approve the special use permit for a substandard lot of record and the dimensional variance for the reasons cited by Mr. Borden.
Thank you. Mr. Reposa.
I think it's a reasonable request and approve both the dimensional and the special use permit.
Thank you. Ms. Horowitz.
I vote to approve for reasons previously stated, both variances.
Thank you. Chairman also votes to approve for reasons previously stated as well. It's actually a reduction from what already exists, which is always a win. So
Thank
Good
you very
luck.
much.
no jokes on your husband, huh? He's probably listening now, but go ahead, have fun with it. Tell him that, and you can't take the deck down either. You have to leave it up. Okay, the next item on the agenda is a petition of Michael and Mary Zani. I hope I'm pronouncing that right. Zani? Oh, not bad. They are seeking a dimensional variance, front yard setback and 2 lot coverages and a special use permit to perform a lot line adjustment and construct a single-family dwelling on a non-conforming lot of record located at 1350 and 0 Anthony Road. Okay.
Listen, I'm Mary. I go by Conley, my middle name. A few of you know me. And my husband is online.
Another one.
Yeah.
Raise your right hand. Swear to tell the truth.
I do.
Full name and address for Teresa, please.
Mary Conley Zani, 1350 Anthony Road.
Okay.
Court Chappelle for the petitioner.
Okay, Mr. Chappelle.
The only thing that's a little complicated is you're kind of doing 2 at once. And they were filed as 2 separate petitions.
I noticed
put on
that.
together. And it's because they own 2 lots.
Okay.
They own 5 lots, but 55-1 and 50 map, tax assessor map 1, lots 55 and lots 56. So
Right.
I think you want to know first just existing conditions. Existing conditions is their house on lot 56 is more than 10,000 square feet, meets every setback, and is 19.6% lot coverage, requires no variances, has no problems. Why is it here? Next door to them, they bought 2 lots that had a garage on it. And it's really from the sins of the past, because as you know, you can't put a garage on a vacant lot as an accessory use. But we bastardized that a little over the years because the gentleman that was across the street owned this spot across the street. And they, at some point, let him put a garage on it. And when it went to be sold, it was sold to the Zannies. So it is separate tax map, separate tax bill, separate tax lot for the 2 lots under the old plats known as lots 56, and a separate tax bill for their house known as lot 55. So those 2 lots together, first of all, abut not only Anthony Road, but a paper street. So they have 2 front yards. The garage on the east is 4.2 feet away from the paper street. The Zannies seek to build a home on that lot next to theirs for Con's mother, right?
That's exactly right. Yeah. Thank you.
So they looked at the size of what they needed. They had to put a septic system on it. They had the septic system designed by Neil Hignorami. And they looked at the width of the lot, and they could have done nothing to their own lot. And if they did nothing, they'd be here saying, I need a variance on the paper street. I need a variance for lot coverage. I need a variance on the west. Instead, the plan was, we have extra land in our 12,000 square foot lot. We can keep it conforming as to size and give a little next door. By giving next door, we can make sure we hold the 10-foot west boundary and require no variance to the west. This configuration allows us to have no variance to the north, which is Anthony Road, as we meet the front yard setback, and we have to move the garage back to do that, but, and no variance to the south because it's the river and we have that much room before we hit Common Fence Point associated land. So the only encroachment is to the east, where the garage is currently 4.2 feet away. It ends up more parallel to the property line at 4.5 feet away, but in our opinion, has limited the variances by adding land onto it. It also ultimately makes two lots one lot, which is generally a good thing for non-conforming lots, although those lots are certainly would be pretty small individually. The house proposed is modest. It's designed a little bit wide with handicap access and things because it's for parents. But other than that, it is, I think, 1,000 square feet. And it meets their needs. So the testimony that I'll go through quickly is it would be more than a mere inconvenience and a hardship. We're doing everything we can, including giving our own land over. Now, the two lot coverage variances are interesting. I had Neil draw it every which way but loose, and we originally drew lot 55 or 56 at right at 20%. That's how it was designed. So there'd be no lot coverage variance. But then they needed an emergency exit off the deck. And they proposed a spiral staircase to take up a minimum footprint. And that takes that lot 0.05% higher than 20%. The second criteria was we were trying to hold 10 feet to the west. And when we drew that line parallel 10 feet, it brought lot coverage to 0.05% on the existing lot that didn't need that variance. So can we put 1% on one, or was it better to split it? I guess that ultimately was up to the engineers and them, but we proposed that rather than have a larger variance on one lot, to split that at 0.05, 0.05, and to remove any setback variances except the one that already exists because of the pre-existing garage. So we think it gets rid of an accessory use on a non-lot. It merges two lots into one. It, in Common Fence Point, creates lots that clearly have substantially less variances than lots of the other lots down there. And because it's the least relief necessary, that's what we're asking you to grant.
Where I'm just a touch confused is when I look at the large map here, I see tax assessors plat 1 lot 56, but there's a parcel 1 and a parcel 2.
56 is actually two lots.
Oh, okay.
But we are merging them.
Okay, that was my question.
We tried to put it just on the front one.
Right, okay,
So that's what I meant by we're merging those two.
okay,
In fact, 55 is 3 lots. They're kind of merged by law because the house already sprawled.
right,
But the house or the garage doesn't sprawl the other lots.
okay, so that'll be merged, all right. Now that makes sense. Got it. So basically you need a special use permit on which lot? 56.
On 56.
56. All right,
And we need on that lot, because the west is a dual front yard,
Yep.
that requires an R10 20 feet. And because we're at 4.5,
right,
that makes it a 15.5 foot variance
and a 0.5% lot.
and a 0.5% lot coverage. And that's all that is needed on that lot. If that's not granted, we wouldn't move the line, right? So if that is granted, then just a lot coverage variance of a 0.5% on their existing lot, because there's no proposed additional anything. And I will tell you, when we counted this, Neil and I counted, we counted every stoop and every, if we just cut the steps out, I think we got there, but it's a very accurate count by Neil on what's there, and I don't know that you always see that, quite frankly.
So lot 55 just requires a 0.06 lot coverage variance, and that's basically to add to the existing.
0.5, 0.5%.
0.5.
I
Petition
I think it is 0.06, but it's not 0.06%, it's a 0.5%.
Okay. Lot 56 requires special use permit. Lot line. Let's see.
It would be a
Building on substandard lot of record.
Yes. And I'll go through that criteria very quickly with
Yeah.
her when you're ready.
And then both the, what is it, a 0.5% lot coverage variance there. And the 15-foot front yard setback, because it's on a corner lot.
15.5 second front yard setback. Yes.
Okay, got it. So you want to run through the criteria?
I will.
All
There's
right.
criteria for the non-conforming lot for a special use permit. And specifically, they want to make sure of a few things. So do you think that as designed, given the paper road on the side and now the distance between the two houses with the lot line, that it's adequate fire protection and safety for both houses?
Yes.
Okay. And there's also a concern that you put up a house and it blocks the light of the other house. I know they're both yours, but you're not getting any closer to the neighbors to the east.
Correct.
And this doesn't affect the light on your unit, your
Correct,
existing
yes.
house or anybody else. Is that right?
Yes.
And the setbacks that we are proposing, they're consistent or even less variances than many of the other houses in your neighborhood.
Yes.
And your immediate abutters. Is that right?
Yes.
All right. And this won't create any substantial public health or other issues. This building already exists on lot 55. 56 is already garage. We're just making it 400 or 500 square feet bigger. Is that right?
Correct.
I believe that's all I have.
Okay. Are there any questions for the applicant at all? Do we have any butters or interested parties up there? Yes, sir, if you want to come up. There we go. Raise your right hand, swear to tell the truth, sir.
I do.
Full name and address for.
Peter Howland, 1334 Anthony Road. I'd just like to support this petition. I think it'll tremendously enhance the neighborhood. And I'm also think it's a wonderful gesture on the part of the family to keep a multi-generational family together in one spot.
Thank you, Mr. Holland. Appreciate that. Okay. Mike, do we have anybody on Zoom?
If you're using the Zoom app, use the raise hand function to give public comment. And if you're dialed in, if you're calling in, dial *9.
Nope. Okay. So, Mr. Borden, how would you prefer this? Want to do one at a time, lot 55 first and then 56, or you want to do them both?
Mr. Chairman, I would just ask a procedural question. The
Sure.
petition states that the relief is for lot 55. I don't see 56 mentioned at all.
Yeah, there's another sheet right there.
All right, so.
I originally filed them separately as two, and Mike thought because they went together and were conditioned, we could do it as one, I think is how it happened.
Okay, all right,
All
thank
right,
you.
So I can review lot 55, they're seeking a 0.5% lot coverage variance, and that's for the purpose of constructing a closed-in porch, correct?
55 is only moving a lot line to 56, so that
Okay.
there's no variances there. There's no additional buildings, no additional lot coverage.
Okay, so it's strictly a special use permit on lot 55 to move the lot line.
I believe for lot 55, it's just a variance to go from 19.6% lot coverage to 20.5
Right.
lot coverage.
So you do
because
need a
we're
0.5%
removing
lot
land,
coverage
Not because
variance.
we're adding building,
Right.
0.5%. I
Right.
don't think we are a conforming lot still, because remember,
Oh,
we're
yeah.
12,000 square feet.
Right.
So I don't think the Article 6 goes to that.
Okay, so the special use permit is the lot line on 55. Okay, that's why I said we're doing separate.
Okay, all right. Mr. Chairman, I'll take them individually and in regards to lot 55, I vote to approve the variance. The relief that's being sought is extremely minimal and to deny would amount to more than a mere inconvenience. In regards to lot 56, I also vote to approve for the same reasons, and I approve the special use permit for substandard lot of record
On both lots?
on both lots.
Okay, got it. Good with that, okay. Mr. Furell?
Mr. Chairman, for lot 55, I also vote to approve the special use permit and the very minor lot coverage variance for the reasons cited by Mr. Borden. For lot 56, I also vote to approve the special use permit, the dimensional variance for the second front yard
Yes.
of 15.5 feet and the lot coverage of 0.5% as minor, and denial would amount to more than a mere inconvenience.
Okay, Mr. Reposa? Thank you. Ms. Horowitz? On both lot 55 and lot 56. Okay, thanks. Chairman votes to approve the special use permit for the adjustment of the lot line and also the 0.5% lot coverage variance on lot 55 for reasons previously stated. And also the special use permit for the putting a house on a substandard lot of record. The 0.5% lot coverage variance there and the 15.5 foot second front yard setback on lot 56 for reasons previously stated as well. So it's been approved. Thank you. Thanks.
Thank you. Thank you very much.
Have a good night. Next item on the agenda is a petition by High Point Avenue LLC seeking a special use permit to construct a 24,000 square foot building for a marine consumer service building in the Portsmouth Industrial Park. Is anybody, they're online? Okay. Okay, who do we have presenting?
Good evening, Chairman and members of the zoning board. Attorney Keith Kyle on behalf of High Point Avenue LLC.
Evening, Mr. Kyle, how are you?
I'm great. How are you?
Doing well, thank you. Go ahead.
Yeah, I just have a couple of brief remarks and then I have two witnesses, if it would please the zoning board. So this is a petition of High Point Avenue LLC seeking a special use permit pursuant to Article 5, Section E14 and Article 7 and Section F of the zoning ordinance to construct a 100 by 240 foot prefab metal building on a 112,678 square foot lot with lot coverage when the building, you know, if the special use is granted of 21.3%. It appears that the design review board and both the planning board gave favorable advisory opinions with respect to this project. I have here to testify in support of the petition Rome Kirby, who's a member and manager of High Point LLC, the owner applicant, and he's also a member of Kirby Marine LLC, who's the proposed tenant should the zoning board grant this petition. I also have Tom Principe of Principe Company, professional engineer specializing in land development and design, who's expected to testify that this petition meets the elements of Article 7, A through J. For purposes of this hearing, and if there's no objection, I'd request that the the documents that are part of the application be, I mean, if this board, I know every board's different, and I sit on a zoning board in Narragansett, I'm not sure what you do, but I'd ask that all those documents be submitted as exhibits for purposes of this hearing, if that pleases the board.
We can do that. I mean, we don't necessarily do it unless it's there, something's entered separate from what came in the application.
All right,
They
very
all
good.
came in with the initial application. They are part of the petition already. It would
Right.
be as if you had to amend one, or you had an expert witness say that brought us a traffic study outside of what you've already given us, then we'd admit it.
Okay, great, thanks.
Alrighty.
So very briefly, High Point Ave LLC proposes, as I said already, to construct 100 by 240-foot prefab building for use by Kirby Marine. It's very similar to, if not the same as the business that they're currently operating at 200 High Point Avenue, which is immediately adjacent to this. So I have, if you'd like to hear from Mr. Kirby first, and then Mr. Principe.
Alrighty.
Are you there, Rome? You gotta unmute, I think.
Yep, I'm here.
I want to raise your right hand, please. Swear to tell the truth?
Yes.
Okay, full name and address, please, for Teresa.
Jerome R. Kirby IV, 10 Gilroy Street, Newport, Rhode Island.
Alrighty, go ahead.
Thank you, Chairman. Rome, you're here with regard to a petition for a special use permit under Article 5, Section E, and Article 7, Sections A through F, correct?
Yes.
And you're a member of the applicant owner High Point Avenue LLC?
Yes.
And you're also a member of the potential tenant Kirby Marine LLC, correct?
Yes.
And your property is located on High Point Avenue, which is known as Tax Assessor's Plat 38 Lot 7D.
Yes.
And this is currently vacant land?
Yes, at the moment.
Okay, and this property abuts 200 High Street, 200 High Street where Kirby Marine is currently operating, correct?
Yes.
And this is located in what Portsmouth refers to as a light industry zone?
Yes.
And is the lot size is 112,678 square feet?
Yes.
And can you describe to the board the proposed building, give its dimensions, its height, and et cetera, just so you can give them a flavor for what it is that's being constructed here?
So the building will be 100 by 240. It'll be 30 feet high. And it'll be for marine services that we currently do next door. We'll be shifting our business next door if granted.
All right, and the documents that have been submitted with the application, the metal building specs and building schematic accurately reflect the building that you intend to have constructed there if this is granted, correct?
Yes.
All right, and you've reviewed the design review board advisory opinion, have you not?
Yes.
And it made certain suggestions and comments regarding lighting, landscaping, and building and safety. And do you have any issue complying with any of those if this board requires it?
No.
Okay. And your petition was also before the planning board on February 9th, 2022. And to your knowledge, the planning board recommended approval of this petition. Is that correct?
Yes.
All right, and you've operated out of 200 High Point, so you're familiar with the area, is that correct?
Yes.
Will your use be detrimental in any way to the surrounding area?
No.
Will your use be compatible with the neighboring land uses in the industrial park?
Yes.
Will your proposed use create any nuisance or hazard in the area?
No.
Will you provide control of noise, odors, and lighting?
Yes.
And you're requesting that the zoning board grant your request for a special use permit as noted in the petition, correct?
Yes.
All right. That's all I have with that witness, Chairman.
All right, I just have a couple questions then, and
Sure.
it goes back to design review and the comments, and I know you addressed them, but I just want to be sure. So for the record, you have, if this board chooses to place those as a condition on this petition, you have no objection to that whatsoever?
No,
Okay. And I know one of those is no location of HVAC was specified, so note there's no rooftop utilities of any kind are allowed. You're good with that?
I'm okay with that.
Okay, just wanted to make sure of that. Okay. All right, those are all. Anybody else have any questions for the app? Okay, that's all I have.
Okay, thank you, Chairman. I'd ask Tom Principe to be sworn in, please.
Mr. Principe, how are you
Yes,
this
Mr.
evening?
Chair. I'm well. How are you?
I'm doing well. Swear to tell the truth?
I do.
And full name and address for Teresa, please.
Yep. Thomas J. Principe III, professional engineer, 27 Secana Ridge Drive, Tiverton.
For the record, could I have a motion to accept Mr. Principe as an expert witness in civil engineering?
Mr. Chairman, I would move that Mr. Principe be recognized as an expert witness in the field of civil engineering.
Could I have a second?
I'll second that.
A motion been made and second to accept Mr. Tom Principe as an expert witness in civil engineering. All in favor?
Aye.
Opposed? Okay, thank you. Go ahead.
All right, thank you very much, Chairman. That saved quite a bit of time not having to go through all that. Mr. Principe, you were retained by both High Point Avenue LLC and Kirby Marine for purposes of preparing a site plan and to render an opinion on whether the petition meets the requirements for a special use permit, correct?
That's correct.
All right, and you're familiar, you already heard instead of me repeating these, you've heard the questions I asked Rome regarding that the land's vacant and the sizes and all that other stuff, correct?
Correct. Yes.
Okay, and based on your preparation of the site plan, review of the building specifications, and understanding of the use the applicant intends for the property, and I believe you personally appeared before the design review board and the planning board on behalf of High Point. Do you have an opinion to a reasonable degree of professional engineering certainty whether the proposed petition complies with the requirements for a special use permit as I outlined in Articles 7A through J?
Yes, I do believe it complies with all those elements outlined in that article. Yes.
All right, and so let me just go through those elements for you so it's a matter of record. Will the use be detrimental in any way to the surrounding area?
No.
Will the use be compatible with neighboring land uses?
Absolutely.
Will the proposed use create a nuisance or hazard in the area?
No.
Will there be safe vehicular access and adequate parking provided on site according to the plan you drafted?
Absolutely. And again, just a note for the board that we do have a approval letter from the fire chief. I'm not sure. I would assume that was submitted for the record, Mr. Chair.
I haven't seen it. Mike,
Okay.
have it?
We submitted it as part of our application. Maybe Mike has it handy, but we
Just ask
did.
Mike.
Okay, we reviewed it in detail with the chief. They had no issues. We had no revisions, and we do have a letter of approval from them.
Okay.
Just want to make that clear.
Okay, great, thank you, Tom. Will any solar rights of abutters be interfered with respect to this project?
No.
Will a proposed use, special use be in conformance with the purposes intent of the comprehensive plan?
Yes.
Will there be any impact on health, safety, or welfare in the community?
No.
Is the proposed use consistent with the purposes of the design standards set forth in Article 9, Section D?
Yes.
All right, and there was one other thing, if you could bring to the attention of the to the board in the design review opinion regarding the dumpsters or something.
Sure.
Could you just
Absolutely.
explain to that how we've resolved that or hope to?
Yeah. Again, I don't know if the board had a chance to review the comments from design review board, but in the letter, I'm just pulling it up now, so bear with me. There was a comment about the dumpster location, about being on an angle, but I just want to make it clear with the board that, you know, it'll be a small, very small 2-yard dumpster enclosure in the back of the building itself, and it will be on wheels. So it's a great point by the design review that the truck, you know, if it was a larger, more stationary dumpster, the truck doesn't have a turning radius to get in and lift it with the forks. So they had recommended something about putting it on an angle but confirming with our client, Mr. Kirby, who's on the other line, that will be on rollers, and it's a very small 2-yard dumpster. It's probably 6 by 5 or 7 by 5. It's a very, very small dumpster. He doesn't need anything large. He doesn't produce a lot of trash, given the nature of his business. So I don't think that's an issue.
I do have a question for Mr. Princeby.
Sure.
What about in relation to the design reviews, the guardrails?
Yeah, absolutely. Yeah, that was a big topic. Yep. So I'm glad you brought that up, Mr. Chair. That was a topic that we discussed at length on our site plans. So if you look at the topography of the site, there's about a 10 or 12 foot grade change from, say, the bottom of the page, which is south, to the top of the page, which is north. So again, we worked a few different scenarios. You know, we even discussed with the client about maybe possibly doing 2 separate buildings. But again, after giving it a lot of thought and a few different options, you know, this was the most efficient option. So with this option, we have to cut the site on the high side, if you will, which would be south at the bottom of the page. And then to the north would be a fill situation. So we have a cut and fill to balance the site to level it out. So on the south side of the site, we have retaining wall system as a cut. And then on the north side is a retaining wall system as a fill. But what we did is we terraced those retaining walls. There's actually a series of retaining wall that actually steps them. So they're no larger than 4 or 5 feet, rather than, again, also from an aesthetic standpoint of view, rather than having one big tall wall that's 10 or 11 feet, we split it up between 2 or 3 smaller walls. And the wall that's closest to the property line and that's closest to the vehicular traffic, it's identified already on the plans that there is going to be a guardrail. I think the question became with design review is, you know, what type of guardrail, what kind? And, you know, there are many options out there, just like picking out shingles and siding. You know, I wanted to just make it clear that it's on our plan and that we recognize from a safety standpoint of view, and the fire chief recognized it, that there will be a guardrail, prevent any, you know, vehicular activity from, you know, moving over to the side of the, you know, going off the travel path, if you will. And through that discussion and discussing with Rome, you know, we believe that the timber guardrail would be the most aesthetically pleasing and structurally sound from a safety standpoint of view. And I believe the design review board also agreed with that, but they wanted to make it clear for the record. And, you know, we're reiterating that tonight. And we want to make sure that everybody knows that we understand that, and that's what's going to be followed through.
Okay, thank you.
Sure.
Thanks for that clarification, Tom. With that, Chairman, we would conclude our testimony, and we'd respectfully request that zoning board grant the petition for a special use permit.
So a quick question for Mr. Kirby.
Yeah.
You have to, there you go. So Mr. Kirby, just, so you're currently in another building up there, correct?
Yes, directly. Like if you see the north side of the building, we're straight across the street.
And I assume that business has gotten to the point where you need to expand?
Yes, we've outgrown the space currently.
And that is a good thing.
That is. We provide a lot of local jobs, so that is a good thing.
Just wanted to clarify that. Okay, does any of the board members have any questions? I have to ask for abutters or interested parties. That's all. And do we have any, Mike, that want to speak? Okay. Prior to voting, I would propose a couple of conditions on this. I'll propose one that I'd like to make a motion that we, this is contingent upon the applicant meeting the lighting, the landscaping, and the building recommendations provided by the design review board.
Mr. Chairman, I would second that. And I would say that, to your point, Mr. Chairman, the petitioner has to comply with all the recommendations cited by the design review board.
Thank you. Could I have a second? I made the motion. You seconded it. All in favor?
Aye.
Opposed? Okay, High Point LLC is before the board under tax assessors map 38 lot 7D. Wishing to construct a building. They require a special use permit. Mr. Borden.
Mr. Chairman, just for clarification, is the petitioner seeking a 1.3% lot coverage variance
No,
as well? Because if I look at the petitions,
0%.
if I look at the petition,
Yeah.
it says lot coverage 21.3%. I'm sorry?
Lot coverage in industrial zones is 25.
All right, thank you.
That's,
Yep, thank you. That answers my question. Thank
There you
you,
go.
Assistant Planner. So that being said, petitioner is seeking special use permit approval only, and the petitioner has walked through all the criterion A through J and meets the criterion under the ordinance. I think this is a good thing for Portsmouth. Petitioner is expanding his business and is not going to create a nuisance or a hazard, and has met all the criterion under the special use permit criteria. So I vote to approve.
Thank you. Mr. Furell.
Mr. Chairman, I also vote to approve the special use permit. The applicant meets the special use criteria, and as stated by Mr. Borden, this will be a welcome addition to that industrial zone.
Thank you. Mr. Reposa.
I also vote to approve the special use permit for reasons cited by Mr. Borden and Mr. Furo.
Thank you very much. Ms. Horowitz.
I vote to approve the special use per variance for reasons previously stated.
Thank you. The chairman also votes to approve the special use permit for reasons previously stated by Mr. Borden as well. So Mr. Kirby, good luck with your expansion.
Thank you. Appreciate it.
Thank you very much.
Thank you.
Thank you, Chairman, members of the board. Thank you.
Have a good evening.
You too.
You
Thank
too.
you.
Okay, the last item on the agenda is petition by Patrick Beck and Z Family Farm seeking a special use permit to hold a 5 and 10K running race as an agricultural special event on 0 Jepson Lane and 0 East Main Road.
Good evening, thank you.
Raise your right hand. Swear to tell the truth?
Yes, sir.
All righty, full name and address for Teresa, please.
Patrick Beck, 248 Spring Street, Hope Valley, Rhode Island, 02832.
Okay, Mr. Beck, why don't you explain to the board what you'd like to do?
Sure, thank you so much for your time. We raise grass-fed beef at Cloverbud Ranch down on Jepson Lane. It's a large property that I leased from Mr. Zerlo. Our frontage is on Jepson Lane, and we've got 6 acres there and causeway across Sisson Pond, and our cattle are on about 70 or 80 acres on the backside of that, what you would see as the south side of St. Mary's Pond if you were passing down Union Street. And I've always learned that you do well by doing good. And we raise this wonderful grass-fed beef. We rotationally graze them around. But small farmers and ranchers we're seeing that we need to do some creative marketing and we need to reach out to the community in interesting ways. And I've always had a desire to be the one to launch a bovine therapy program. And we've done it. This past fall, I met the head clinician for the Oceantide School in Narragansett, which is a school for troubled court adjudicated youth. And I asked Dr. Vogel if she'd like to bring the boys over once a week to work with the cattle and be out in nature and experience. I could perhaps share some positive lessons with them using the cattle and their opportunity for animal contact. And we initiated that this fall. We had the cattle, had the kids come out on 4 separate Wednesdays, and it was fantastic. And it's a special thing in my heart I put in the narrative because we just lost my mom, who was a wonderful teacher for 4 or 5 decades. And she had reached out to children like that frequently in her life to no one's attention. So it's very important for me to let Cloverbud Ranch be the place where bovine therapy is being done. You've probably heard about equine, you've probably heard of equine therapy that's gotten a lot of attention, but not many folks, or no one to my knowledge has used cattle, and particularly beef cattle. So this is a production herd. These animals are going to go to slaughter, but it gives us an opportunity to speak to the boys about circle of life and lots of things. So that's great. We've launched bovine therapy. And the point of this spring event is to bring the Oceantide School there for a fundraiser, 5K, 10K, that we're calling the Ranch Run, and a little barbecue. It's their spring fundraiser. So they're, instead of a black tie dinner at the Dunes Club in Narragansett, they're gonna have, or we're requesting opportunity to have a little 5K, and people can walk it or jog it. And it would be on Sunday afternoon, May 15. And we would accommodate the visitors with a van, a shuttle service from the Portsmouth Middle School parking lot, with a little shuttle van that the school will provide. And that's all in your info. So that's the gist of it. We'll have some folks running around the cattle in the field so they can participate in it and be out in nature, and have a ranch barbecue that Diego's is going to cater for us.
Okay, just clarification, and I don't see it on the application. Some reason it's in our, but this is strictly on Jepson Lane, not on East Main Road, correct?
Correct. We have an easement that comes from East Main Road down Paquin's Lane, but we will not use that. Our property is, goes up to it. We abut the back of the church, the west side of the church property. You can probably see on the, so we abut the west, the fields behind St. Mary's to the west. That's our eastern boundary. So we will not approach East Main Road at all.
In your special use permit request, you gave date, time, and about 11 bullet points. Just to clarify, no live amplified music or band.
Correct.
It says parking will be accommodated at the middle school. Request has been approved already, so you've already been before the school committee for approval to park there?
Yes, we've got that, and that was communicated directly to the leadership at Oceantide School.
If required, a police detail can be arranged. How is that determined?
That's determined that it will occur. I spoke with the fire marshal. He said that he thinks a EMT detail being assigned to it's a good
Well,
idea.
that's the EMT, but the one just before that was a police detail.
Oh, I was just going to leave that to you. If you felt that there was a risk or a danger to vehicles coming or leaving the school on a Sunday afternoon, I was mindful that that might be an issue.
Well, I think in that particular case, at least I may propose a condition that at least this be run by the police chief, and if it's determined that one would be needed, then they.
Sure. I'm sorry, were you done?
And then, one more thing, number 11, 2 porta potties would be available at the start finish point. 2 porta potties, do you think that's enough?
I do.
Okay.
And I'm open to,
No, I'm just, there's gonna be 100 to 150 people. There's gonna be food, drinks. I'm not thinking 2 porta potties is gonna do it. I'm not a porta potty expert.
Okay.
I just would be concerned people who are using the surrounding area if they needed to use the restroom.
I'm open to, let's not
I
trip
don't
up
know, I'm
on
not a
that-
porta
on
potty
that.
expert, so I don't know.
I
but-
don't think folks would use around the area, because when the barbecue is going on, it's going to be kind of a lot of folks right along Jepson Lane. So other waste depositions, I don't think are a concern. I would love to make sure that we were adequately serving the visitors. And so I had just written 2, and then if that needs modification, the Hallmans are right here. I'm sure they could drop off more than 2.
Okay, I'll leave that up to you. I will just address your last thing. We'd like to request we waive the $200 this board doesn't have that authority to waive our fee.
So, oh, okay.
Okay,
I just wanted to remind you all that I donate
right.
2.5 acres to the middle school for
Right.
zero and pay the tax and pay, I did not get Mr. Zerlo to reduce my lease at all. So I was looking for a pat on the back for that.
I understand that. Okay, I don't have any other questions. Does anybody from the board have any?
But I just wanted to respond to the police issue.
Yeah.
What's nice about the van, that pulses people coming and leaving. So it's not like if one left the Xfinity Center after the Rolling Stones show, that's a mass exodus. This is not that.
Right, but there are gonna be a number of 100 to 150 people with cars going to the middle school, whatever. So just, and the overall event itself. So I would just, and again, that's something I would consider placing a condition on. It would have to be voters, whether you have to actually do it, but I would feel more comfortable if the police chief actually.
I agree with you 100%, and I would, we'll make sure that that is someone who is consulted about their feelings about it.
Is there anything else you'd like to add?
No, it's exciting for us. Well, what I'd like to add is that our grass-fed beef could be in all of your homes. Because it's at the boathouse and we raise really special grass-fed beef. We graze them up about 3 years old. So it's a really special European style beef. And so we sell to the retail, not just to the fine restaurants.
Thank you. Let me see if there's any abutters or interested parties to this.
No, so it's, we're fortunate to be able to follow our passion and do a regenerative grazing. So we're improving the land with these animals and like to share that mission with the community.
Mr. Lacerda, want to come up? Been a while? Been a lot of years. Raise your right hand. Swear to tell the truth?
Yep.
Full name and address for.
Joe Lacerda, 324 Union Street.
Go ahead, Joe.
So whatever he's got in mind, I'm not against it, but I seen 0 Union Street, East Main Road. And that's my property.
I just addressed that.
There are actually several 0 East Main Roads. It's, if you don't have a building on the property, it gets listed as 0.
Okay, and he was,
For some reason, even though the property doesn't abut East Main Road in our tax database, it's
At 0
East Main Road.
Yeah, that's,
so I wanted to ask you, you were mentioning St. Mary's. Your land abuts. You're gonna have people coming through there?
No, you can look right on the map here.
Oh,
So the start and finish is on Jefferson Lane and they'll jog across. Let's look
well,
at it
I
together.
know you had mentioned
Okay.
St. Mary's there.
can
So
you
the
come, can
property
you,
abuts the west-
gentlemen, can you come around this way so we can see what you're pointing at?
So the right side of the drawing is the east boundary of our property, and that abuts you on southern portion. Field.
I think
No, it would be dangerous no, everything starts and ends there and they'll walk, just where the cows walk, and that's the only place.
So, okay,
Good, Mr. Lacerda?
am I good? I got a couple more things if you,
Go
I
ahead.
know it's getting late,
No.
but I just wanted to address that.
Yep.
There is a farm use only right away on that lane. So
That's why this is.
for
under-
traffic or,
This is before us under an agricultural.
we've been here
permit.
with this already, yeah. And the lane cannot take an ambulance. It's too steep.
Right.
So with that, and our land runs together down the bottom. There's no stone walls.
Okay.
And there's gonna be a lot of people and people wander.
Nobody's gonna wander, we're gonna mark the course.
You know how it is down there. You can just like right in here, you can walk right out in my property from yours. If there's nobody watching them.
Please finish it.
So liability. I'm hoping he has insurance. Someone falls in a hole down there or
It's a good question. Mr.
I
Lacerda.
don't want to be liable. I don't want him on my property, period. What he does down there, that's fine.
Right, right. Okay.
Yeah, safety first.
All right. Absolutely.
And now I understand what St. Mary's.
Okay.
So they just purchased Matosa Lane. That's another
Yeah.
right away for you.
Right.
If
Yeah.
Yeah. So you're gonna try to put something down below our properties to,
Hey, Joe, I'll deal with that.
oh,
I'll deal with
okay,
it.
yeah.
Yeah.
Big thing is insurance.
Okay.
Good point, sir, and that's why the school has a special insurance policy for the day that is being communicated to Mr. Zerlo. No one is more concerned about insurance than Mr. Zerlo, my landlord. The school is providing insurance for the day. The course is going to be marked, and I can assure you, folks aren't going to wander off. They're not there to wander.
They're not gonna, yeah.
Okay, can we, don't, I'll address that. Okay.
Okay, that's all.
All right. Thanks, Joe.
Thank you.
All right. Anyone else? We know there's no one up there. Okay. Mr. Beck,
Yes.
do you have any objection to where those two properties abut? Put up some sort of temporary snow fence or something. I mean, it's one thing to mark a course and people not to go over it, but just marking a course usually doesn't stop people, so.
There is a wall of brush and it is impossible, it is virtually impossible to cross onto his
Okay,
place right now. So it's not, well, that's a line.
but you can put signage up
Yeah, sure.
that says
What I'm saying is a fence would be irrelevant because there is already
brush.
a formidable vegetated barrier.
What I'm going to do is probably propose condition where that abutting property line, where that brush is, be marked
Sure.
some way that says, no trespassing beyond this point, something to that effect.
Right.
That lets people know, don't go there.
100%.
That being said, before we hear this, I am going to propose two conditions to this. Condition one will be where the proposed course abuts Mr. Lacerda's property, that along that, there be signage put up that is marked, no, do not trespass beyond this point, something to that effect. Notice that that is private property. And the second will be that the applicant go before the police department for their opinion on whether a detail would be needed for this, and to abide by whatever the decision is made by the Portsmouth Police Department. So those two
So
conditions-
moved.
so
Mr.
moved.
Chairman, I move that the two conditions proposed by the chairman be put into the record.
Thank you. Second. Motion been made and second that the two conditions proposed by me will be placed in. All those in favor?
Aye.
Opposed? All righty. It's not my problem. All righty. So the applicant is before the board for an agricultural special event, it's Article 5, Section C5. Mr. Borden.
Mr. Chairman, I think the petitioner is coming in front of us in good faith, and I think this is a good thing for the town. And I don't see any objection in regards to all the special use criteria. I think the petitioner has met all the criterion. And I think the abutters and surrounding properties are protected. And I think he's met the criterion, and I vote to approve.
Thank you very much. Mr. Furell.
Mr. Chairman, I also vote to approve. The applicant has met the special use criteria, and this will be a well-run event.
Thank you very much, Mr. Reposa.
I also vote to approve. So we're gonna protect all the neighbors' property and wish you the best.
All righty, thank you. Ms. Horowitz? Thank you. The chairman also votes to approve for reasons previously stated, and I think by placing those conditions on it, it will just make it a little bit more safer. To Mr. Lacerda's point, safety should be everything in this.
100%. We care about being a good neighbor, and we'll abide and make sure that our guests that day are aware of how to be a good neighbor.
You've been approved.
Thank you. Thank you.
Motion to adjourn?
Motion been made and second to adjourn. All in favor?
Aye.
All opposed? Didn't think so. Thank you all. Long time, Joe. I haven't seen you since Christ was a baby, for God's sake. How you been?